Yes, please.
We are permitted to mention one order 41.
Yes.
There is some urgency in the
So
execution.
it will appear in the list. To take up. Yes.
Application.
For application.
Your Lordship is kind enough to allow me to mention hearing matter.
Hearing we are not taking up now.
So there is an
Thank you.
order 41 along with the application, my lord.
Please.
Remember me, Lord.
Lordship, may I be permitted to mentioning for inclusion?
What?
For admission.
Application.
Huh.
Admission.
Admission.
Yes.
Lordship, may I permit an application?
Application and order for turn, please hand over. Application and order for turn need not mention, just hand over.
Lordship, the year of the appeal is 2016. Lower court record came praying for preparing paper book, Lordship.
You want a direction for preparation of paper book?
Yes.
It will appear right to be mentioned on the top of the slip and hand over.
Application.
Lordship, this matter is arising out of a money suit
What is the category of the matter? Application or order for turn?
appeal.
Appeal
Let me
hearing?
Yes.
No, hearing or not.
Lordship, this is an application, but interim order is
Hand over.
Lordship, interim order expiring tomorrow, my lord. If
Yes.
some precedence can be given.
Any other mentioning?
Lord, if your Lordship
Yes,
permits me to mention, Lord, a matter from the list.
Yes.
It's item number 102.
Yes.
The next party matter, Lord, the probate proceedings was dismissed for default. And Lord, the restoration application was also dismissed. So, my Lord, we filed this appeal. Your Lordship, Lord, directed substituted service, that's also done. Nobody has entered appearance. But this just for restitution, Lord, if your Lordship kindly considers this, Lord, as for orders.
The probate case itself was dismissed for
dismissed
default.
For default. And Lord, restoration application has also been dismissed. So, Lord, his appeal is against that restoration.
It will appear as specially fixed matter tomorrow.
Much obliged.
Kalke specially fixed দিয়ে দেব.
Much
Mr. Court, please ask your learned
Yes.
junior to give a notice to the other side.
There is no other.
Oh, yes, right.
Your Lordship, I beg your kind leave to make a
Application?
No, sir. Your Lordship, it's pertaining a few minor corrections, suggested corrections. Yes. Your Lordship, there is one more matter. It is also for hearing, but here the appellant was directed to file paper books within 6 weeks, but they have failed to file any either before the court as well as they have not served upon us. It's been a long time. The order has been passed. If the matter,
If you want a direction for paper books, we can direct you. You are the respondent. We can direct you, but write to be mentioned and then hand over the slip. It to be mentioned. Yes. Yes. Yes, quick, ma'am.
I'm mentioning one FMAT for admission.
Yes. Call on the list, ma'am.
Gratefully,
May I be permitted to mention, my lord?
What is this? What is this? What is this? Application or order for turn?
My lord, application, my lord.
Hand over. Call on the list, please.
One, my lord, I'm for the respondent. My lord.
Use the microphone.
Item number 1, my lord, I'm for the respondent. This is
Yes.
appearing at my instance, my lord. And what has happened on 9 July 2019, there was an order passed by the division bench that the appellant shall pay 9,000 rupees to the respondent.
9 July 2019.
Yes, 9 July 2019. Pay 9,000 rupees to the respondent by the appellant every month, and the same will increase by 5% every 2 years. Now, my lord, what the appellant has done, from 2021, they are paying me 4,500 rupees monthly, and thereafter filed an application herein in the High Court in 2023, Can 5 of 2023, appearing in the list also, that they are praying for modification of the order. But without obtaining any order, they are constantly paying from 2021 to
When
till
application
date.
is pending, we'll decide that. Along with that, we'll pass necessary orders.
My
What
lord,
is the question of mentioning? Which is the item number?
and item number 1, my lord, the application is, they are showing that the application is pending, but the application has not been moved. It is Can
It's
5,
Can 5.
Can 5 of 2023.
We'll put Can 5 in the application list for hearing. Suppose we'll put that. Learned counsel for the respondent submits that although an order of payment of alimony was passed, the appellant has not been paying accordingly. Full stop, next para. It is further submitted that Can 5 of 2023 is pending at the behest of the appellant for modification of the earlier order directing alimony. Full stop, next para. Let Can 5 of 2023 be listed tomorrow under the heading application. That's Next.
My lord, I was told by the department that the Can 5 was not located. My lord, if that's the same, my lord, I can give copies to reimburse. My lord,
Bring extra copies.
my lord, I have today.
Not today.
Okay. Deeply obliged. Deeply obliged.
Next.
Lordship, I'm appearing for the respondent.
Why appearing is to be mentioned? Mr. Ali, you mentioned.
No, but this is for filing of notes of argument.
Oh,
Lordship, we have prepared the notes of
It's fine.
argument.
both of you.
And Lordship, on the point of natural justice,
Any point of?
on the point of natural justice, my lord, I have brought one decision. Would be Lordship's pleasure to.
After hearing, no. After hearing is concluded. You should have given them a notice also. You gave a copy of the written notes to them.
Just now we gave.
Just now it won't.
Lordship,
If
the
you want to
hearing-
deal with that judgment, we'll take that judgment. We'll keep it as to be mentioned tomorrow. Learned counsel for the appellant. একই আছে একই জিনিস দুজনকে দিয়েছেন আপনি আমাকে ওইটার দুটো কপি আর ওটারও দুটো কপি ওনাকে দিয়েছেন আপনি উল্টো হবে তো Notes of arguments filed by the parties today be kept on record. First of learned counsel for the appellant seeks to rely on a further judgment. Full stop. Let the matter be posted under the same heading tomorrow to enable learned counsel for the respondents to come prepared with his response to the fresh judgment sought to be cited by the appellant. Give him a notice of the
I have given the judgment itself.
judgment.
Lordship, I've also, in my notes, Lordship, I have given a note list of dates also.
এখানে আজকে কনক্লুড করছি নেবেন ওরা ওই জাজমেন্টটা দিয়ে দেবে তারপর কনক্লুড করবে নোটস লেখা কালকে তো এটা না অন্য এটাই চেয়েছিলেন হ্যাঁ এটা বলে লিস্টে থাকবে বলে বোধ আসছে কালকে হয়ে যাক কনক্লুড
Great.
I appear on behalf of the petition.
yes ma'am, what is the matter?
But for non-prosecution, my lord, as we-
Non-prosecution? You are for the appellant must be. Learned counsel for the appellant submits that the appellant does not want to proceed further with the matter and hands over a photocopy of the written instruction in that regard. Full stop. Let such photocopy filed today be kept on record. FAT 203 of 2025 along with Can 1 of 2025 are dismissed for non-prosecution without any orders to cost. You are for the other side in the
Next matter. For the respondent.
respondent.
I appear for the appellant, my lord.
You are for the 1 and 2, not only 1. On the last occasion, someone appeared for 1 only. Mr. Owen Banerjee had appeared for 1. But you are appearing for 1 and 2. In the slip which you give, write 1 and 2. Yes. Yes, Mr. Shen.
My lord, this is objector's appeal, my lord. Probate has been allowed by the learned trial judge, my lord. My lord, may I hand over the
Are
copy?
there paper books in the matter or we intended to hear on the
Well, paper books are required. my lord.
The informal paper book is there.
paper book? Kothay? Informal paper?
We have been served with informal paper.
Have you filed it in court?
My lord,
When did you file it, Mr. Shen?
my long time back, AA 60
The department.
department, my lord, just endorsement
Paper
is
book
there.
নেই কেন তাহলে?
From the department itself, my lord.
ফাইল হয়েছে পেপার বুক দেখবেন না
Lord,
Your
after
name?
mentioning, it was
Why?
because Lord, respondent number 3 is an octogenarian, what I mentioned.
Yes, Mr. Shen.
My lord, this is the
Please be as brief as possible, both of you. Because we are hijacking the order 41 and the application matters.
Lord, I thought, my lord, it will appear after the order 41 application as specially
It
fixed.
must be very candid, my lord.
কিন্তু order 41 oh no, Yes,
Must be very candid, at the time of mentioning, my lord said after the part matters, this will appear.
after the part matters, this was যেটা আপনি উপরে
Specially
দিয়েছেন
fixed.
কেন?
This
অনেকটা
was the observation from the
On
court.
Thursday, my lord,
স্পেশালি
just
ফিক্স
after the
কিন্তু আমরা
part matter.
বলেছিলাম এটা পাঠার ম্যাটারের পরে থাকবে। পাঠার ম্যাটার let it appear after the part matter tomorrow.
I don't mind, my lord. This
Thank
was
you
the
very much.
observation called from, fallen from.
Thank
court,
you
my
very
lord.
much for the fairness. Since the matter is to be heard on merits, comma, let the same be listed under the same heading tomorrow, immediately after the part heard matters.
I have another prayer, my lord. My lord, there are two wills, my lord. One by the father, one by the mother. Mother's will, my lord, has been decided in our favor, and the father's will has been decided in their favor. My lord, there is, so far as the facts are concerned, my lord, there is some relation with that, so far as the wills are concerned.
Those are
My lord,
absolutely separate.
But if this prevails, then that goes.
No, no, my lord, there is nothing to like that. my
Like
lord.
that, my lord.
No, it was.
No, then.
But I was humbly praying, my lord, both the matters should be taken up together, my lord, because there is, my lord, my lord,
There'll be
I will
unnecessary
renew
complication.
my prayer, my lord, after going through the family
Yes.
tree, my lord, I will renew my prayer.
That appeal is ready also.
That appeal is theirs appeal, my lord, they are delaying. It is our appeal, my lord, which
So
was,
we'll hear this out, whatever.
my lord,
এই স্পেশালি ফিক্স ম্যাটারটা না ইয়ের পরে এটা হচ্ছে স্পেশালি ফিক্স মানে হিয়ারিং এর মধ্যে হিয়ারিং এর উপরে তুলবে বলে স্পেশালি ফিক্স। এটা পাঠার আর হিয়ারিং এর মাঝখানে ঢুকবে কাল পাঠারের পরে। থ্যাংক ইউ কল।
But the wife defendant responded in a matter.
My lord, I am for the
Yes, Mr. Muthu, what is that?
petitioner husband. And this is the letter I have. My lord, my application.
Which application shall we take up first, Mr. Muthu? Can two or
Two
three?
applications, one application filed by my learned senior, that is scan 3, and my application old 12225 of.
What are the respective applications? They are the appellant.
Yes, in my application, I have paid for enhancement of the alimony pendant.
What is this removal of padlock, Mr.
My lord.
Muthu? Why removal?
This is my lord.
With the
My
context.
lord, I have a flat at Rajarhat,
This is a matrimonial appeal.
my lord.
You have challenged a divorce decree
Yes.
or dismissal of your suit.
Yes, the degree is
They
under.
obtained divorce.
Yes.
Very.
No, they didn't obtain. I filed the,
That's what
So-
we're asking.
so
Your
my-
suit has been dismissed.
yes, suit was dismissed.
Right,
Against
right.
that, my lord, appeal.
Why
Now,
removal of
alimony
pad-
was passed during,
Why removal of padlock?
my lord, padlock, my lord. I have a flat at Rajarhat.
Yes.
Now, my lord, it was purchased by me during some time, my lord, from May 2024, and for a period about few days, we were residing there. We tried to, my lord, I tried to compromise, but my lord, ultimately, my lord, I don't make any allegation here. Ultimately, I could not stay. I left the flat. Well, I had a one key and one key was kept with her. Now, well, when she left the flat, my lord, 21st June 2024. No, I left, my lord, 21st June 2024. Thereafter, my lord, she left the flat last week of September 2024. Then, my lord, he put a padlock on the gate of the flat. So, my lord, though I had a key of the flat,
It's a new lock, so you
new
can't
lock, my lord, so I could not.
want a removal of that.
This is my lord.
Yes, how can you prevent him from doing that?
Totally, my lord, incorrect submission has been made. I am.
What is your
staying-
correct submission?
Not correct.
Take the mic
Kindly
towards you.
see.
Take the mic towards you.
My lord, I am always staying there. Only one day.
A new padlock has been put.
No. Why? Only one day I went to my brother's house.
Yes. Then
On that date, he went there and he did not find. And that is the reason made the incorrect allegation paragraph 7 to 10, my lord, kindly see.
reason for what?
Reason saying that I am I have gone to my matrimonial parental house since long, He is not,
Not that's a different part of the
Yes.
allegation
No,
that will
I
deal in the
cannot.
appeal.
I cannot, I cannot.
But they have
I-
asked, they have said that you have put in a new padlock there.
It is an incorrect statement.
You will
Incorrect
hand over
submission.
you will hand over a key, one of the keys of that padlock to him.
Yes, always there. It is the
By tomorrow.
door, outer door lock. Only one key I put on on just
Whatever
one.
key you have put to which he does not have a counter key, give him a duplicate.
And that is there. Now
tomorrow?
he is not staying with me. He is staying.
Forget that.
I shall.
He has a
give
right
your
to
lordship
access
direct.
like you.
No,
You
no,
also have a
all
right.
right, all right, all right. Not,
So we'll
nothing.
dispose of this application directing you to hand over a key to the lock which you have, new lock you have put by tomorrow.
I shall not put any lock except the key with him. Or can you record that?
Very well.
Record
Very
that.
Whatever key is with him, no other lock will be put. If
Will
you have
be.
put any other padlock, that
I
will
shall
be
not.
put by you by
Can
tomorrow.
you record that?
By tomorrow. It's not a padlock, it's a lock.
Lock. It is a lock. It is a lock. I shall not put any lock which is not key with him.
We'll keep it as to be mentioned tomorrow in front of court, just hand over.
I shall.
Oh, you are
Key
saying.
is with him. Another.
Acha, Mr. Moitro, they are saying that they have put in not a padlock but an ordinary lock.
Yes.
They'll remove that lock by today. By tomorrow. In fact.
Yes. Another key is
My
with
lord,
him.
if key is not handed over,
No, the other key remains with you. They'll not
Yes,
put
yes.
any other lock.
No.
Then
I shall not.
to
make
which
any
you have a
extra lock.
whatever lock was there, to
Yeah.
which you also have a key and
yes,
he also
yes,
have a,
yes.
that will only be there. Any other lock, if put by her, will be removed by tomorrow.
My lord.
We'll dispose of the application by that. If
My
they
lord,
don't
my
do it
lord, my lord.
contempt,
Let it
My
be
lord,
there
I'll-
as it was. And one our application is before your lordship
lord, we
sees.
kindly
so we'll take up that next one.
My lord.
And
direct the police to see
It is not required.
not at this stage. If
because
not
I went to
Just
police.
staying with.
done, mention before us,
My-
we'll pass approval.
It is my responsibility. I shall tell.
Can 3 of 2025 is an application filed by the appellant husband in an appeal filed against the dismissal of the appellant apostrophe S suit for divorce. From next para, learned senior counsel appearing for the appellant submits that taking undue advantage of the absence of the husband for a limited period, comma, the respondent wife put an additional lock to the premises in question, comma, where the of which the appellant husband is the owner and has a right of residence equally with the respondent wife. Full stop. Next para. Where is that? What is the address of that? Which one? Your address or her address?
This premises address is there. But
Which one? Your
paragraph
address
nine-
or her address?
Yes.
Paragraph 9.
Yes, yes, sir. Paragraph 9. Newtown,
Full stop. Next para. Learned
Number-
counsel appearing for the respondent wife submits that in order to protect the property, comma, since the husband was absent and the wife had left two, comma, an additional lock was put to the outer entrance of the premises. Full stop. However, comma, learned counsel submits that the respondent wife shall immediately remove the additional lock. Full stop. Insofar as the previous padlock of the premises is concerned, comma, it is an admitted position that both parties have keys,
yes.
chabi, keys to the same. Full stop. Next para. Thus, comma, the problem created by putting of an additional lock may be alleviated in the event the wife is directed to remove the additional lock, comma, retaining the original padlock to which both parties have keys. Full stop. Next para. Hence, can 3 of 2025 is disposed of by directing the respondent wife to remove any additional lock which she has put on the outer or inner entrance of flat number D4, comma, Uttorasha apartment, Uttorasha, একটা কথা, apartment, comma, Solua, SOLUA, comma, Azad Hind Gar, GARH, comma, besides Noboru, NABARU, Sangho, comma, Kolkata 700136, comma, by 12 noon tomorrow. Full stop. Next para. It is made clear that the only padlock which will be retained at the premises is the original padlock, comma, of which both the parties have keys. Full stop. Next para. No address to costs.
No one prior.
My lord, only
No,
I,
my lord,
I'm saying,
additional belongings may be removed from that flat.
I also, my lord,
My appearance.
You can do the same. That applies to you also.
my lord, besides my lord, Nobadun Shanku, not Nobadu. But there is mistake, my lord, only N,
Novarun Shankho?
Nobadun Shanku.
আচ্ছা যেখানটা নবারূপ
Paragraph 9.
নবারু বলেছি একটা লাস্টে এন হবে নবারুন
No,
we were thinking that because that area নবারুন সংঘ is there
my lord, it's a mistake, my lord, your
so
lordship.
that additional order we are not passing because that will apply to both of you if you do that then you have
Maintenance, my lord, I am waiting since 2017.
no
But
maintenance
no,
will
no.
take up now the next application
My lord, my
yes what is can to
my lord,
enhancement
it is believe I believe can to now new.
yes we also believe because it is before us
1225 of 2007.
it's before us it's for enhancement
Yes.
Acha, if you file an application for enhancement, you have to file your current affidavit of assets also because it's also under section
He
20.
is not supplying all this. How can
Your current affidavit of assets have also to be filed.
But I am unworking lady.
You have to file an affidavit of asset as per Rajneesh versus Neha
I shall.
because every order of enhancement is also under section 24.
My lord.
Whenever we pass an alimony order, we have to take current affidavits.
My lord, may I get a copy of this?
I have copy
No,
of
no,
it.
why may you? You have a right to get.
এই copy দেওয়া আছে স্যার
Let us pass our directions. Let us pass our directions. If you are in difficulty, you just point out to us. Can 2 of 2017 within bracket old number can 12225 of 2017 bracket closed comma is an application for enhancement of alimony pendentity granted by this court comma filed by the respondent wife. Full stop. Next para. The respondent wife shall file her affidavit of asset, her current affidavit of asset in support of the said application. How soon can you do that?
1 week.
Within a week from date, full stop. A copy thereof, comma. You have got a copy of
Along with this copy, along with
a copy thereof, comma, along with can 2 of 2017,
My lord.
comma, shall be served immediately thereafter on the learned advocate on record for the appellant husband. Full stop. The appellant husband shall use a composite affidavit in opposition
My lord.
to can 2 of 2017 as well as the wife apostrophe s affidavit of assets within a fortnight thereafter.
My lord.
Full stop. Along with the same comma, the appellant husband shall also file his current affidavit of assets. Full stop. Next para. A copy of the affidavit in opposition as well as the affidavit of assets of the husband shall be handed over immediately thereafter to the learned advocate on record for the respondent wife. Full stop. The respondent wife shall file a composite affidavit of reply to the affidavit in opposition of the husband as well as his affidavit of asset within 1 week thereafter.
Yes.
Full stop. The application shall be listed in the monthly combined list of cases for the month of August 2025 for hearing.
My lord.
Grateful to you.
Thank you very much. But please ensure that the key is
I
handed.
shall. It's my
You
responsibility.
personally ensure.
I have. It's my responsibility personally. Grateful. বলে দাও কিন্তু তালা যেন না মারে। Much obliged.
Thank you. 6.
It please your lordship, my lord, for this.
What is this application?
These
Dispose
are
of
one of
matter?
the occupation charges which we deposited pursuant to the order of this honorable court since my lord October 2018 till my lord May 2025, that is lying with the my lord, Treasury High Court. Total 80 deposits at the rate of 10,000. That
Give
order,
us half a second. You have given a copy of this application to the other side, no?
my lord, I could not, my lord. My lord,
Directly
I
to give
come
a
back after-
copy and come back next week?
My lord, it's my mistake, my lord.
The present application is substantially for withdrawal of occupation charges made by the appellant. Full stop. Next para. A copy of the application shall be served by the appellant on the learned advocate appearing for the respondent in this court at the earliest, and a receipt in that regard shall be filed on the returnable date. Full stop. Let the application be listed on June 30, 2025 under the same heading.
I'm ready.
My lord, I seek indulgence to appear online, lordship,
Yes,
for
please.
appellant. Lordship, my junior is handing up the affidavit of service.
Yes.
Lordship, as per lordship's direction on 13th May, we have served the respondents.
What are
both
the
the
envelopes? I mean, why 2 affidavits of service? Only one
Uh,
affidavit?
One is copy, lordship.
Acha, why, what are the envelopes?
Lordship, the both of the envelopes returned back with ambiguous notes that it could not be located, but it's a company and it's a registered address. So there is some play, I think, Lordship, because they are avoiding it. It was a summary suit, wrongly, if I may say so, rejected by the London Trial Court.
Huh.
So for that, we have come into appeal, and the delay was mainly due to Lordship, the pain down strike in 2019.
Yes.
That was the Howrah Court incident, Lordship. So this we have served. If Lordship may be pleased to condone the delay, and Lord.
The affidavit of service filed today be kept on record. Full stop. The envelopes returned with the same indicate that insofar as respondent number 2 is concerned, comma, who is one of the directors of the respondent,
Number 1.
who is the director of a sister concern of the respondent number 1 company, comma, has returned with the endorsements that despite service of intimation, comma, the postal article was not collected by respondent number 2, full stop, we deem the same to be good service. Full stop, insofar as respondent number 1 is concerned, comma, learned counsel for the appellant submits that although the envelope has returned with the endorsement addressee could not be located, comma, the address at which it was served and appears in the cause title is the registered address of the company. Full stop. In such view of the matter, comma, we construe the service on respondent number 1 also to be a good service, comma, since sufficient attempts have been made to serve at the last known registered office of the company, but the company is deliberately avoiding service. Full stop. Next para. Thus, comma, the application is taken up for hearing ex parte since the respondents choose to remain absent. What is the delay?
Lordship, it is calculated at 128 days, Lordship, by the department also, because
What is the reason for the delay, Ms. Gurupriya?
Lordship, there were several reasons. Like it was a shocking that a summary suit was dismissed by the trial court, and thereafter more than 4 months there was pain down in High Court, so we could not take steps within time. Lordship, I have tried to explain in the application. Lordship kindly sees page 4, 5. Starts from the explanation starts from page 3, Lordship, and then
yes.
Lordship kindly sees page 4 and 5. Lordship, there was pain down, Lordship. That was a very talked about case about the beating of some lawyers in Howrah Court and all that, Lordship, if I may just mention about that. And that we have mentioned in paragraph 12 also, Lordship. The strike call was continuing till May 19, and it was lifted only in June, Lordship, and thereafter we filed it immediately. So, Lordship kindly condones the delay.
Just let us just go through that, the amendments.
Lordship.
In the present application for condonation of delay, comma, it has been pleaded that the appellant took a decision in due time after dismissal of the suit for preferring an appeal against the same and accordingly sought legal advice from the learned advocate appearing for the appellant in the trial court. Full stop. Upon a conference being fixed with a learned advocate practicing in this court, comma, the appeal was drawn up. Full stop. However, comma, before filing the same, comma, a pen apostrophe is down called by the Bar Council of West Bengal commenced, which prevented the advocates from filing the appeal, comma, since the infrastructure for filing such appeal had failed due to the said pen apostrophe s down. Full stop. Next para. Subsequently, the summer vacation intervened, and thereafter, comma, as early as possible, comma, the appeal was filed. Full stop. Next para. Although the seize work and pen apostrophes down calls by the Bar Association stroke Bar Councils has been held to be illegal, comma, seen from the perspective of the litigant, comma, the litigant was not at fault for the appeal not having been filed in time. Full stop. Next para. Therefore, comma, although deprecating the practice of calling seize works in consonance with the judgments holding such strikes to be illegal, comma, we find sufficient substance in the contention of the appellant, comma, that the appellant was not at all negligent but diligent in pursuing its recourse, but was unable to do so due to circumstances beyond the appellant's control. Full stop. Accordingly, we condone the delay in preferring the appeal. Full stop. Hence, can 1 of 2019 within bracket old number can 7605 of 2019 is allowed ex parte, thereby condoning the delay in preferring FAT 350 of 2019. Full stop.
Deeply grateful, Lordship.
Thank you. Next para. The appeal be deemed to stand registered and admitted accordingly. You have no other application, Ms. Gututia, so you are directing
No.
paper books and all.
Yes, Lordship.
Very. The appellant shall put in due requisites and postal costs for service of notice of the appeal on the respondents within a week from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. Stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned counsel for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
Deeply grateful, Lordship.
Thank you so much.
I take leave.
এই লিস্টটা চলে গেছে সঙ্গে সরি
Item number 8, my lord, I appear for the
for the respondent, Mr. Sen.
My lord, the last day, my lord had directed service upon the appellant, my lord, learned advocate for the appellant, my lord, she told that she had given no objection. My lord, thereafter, my lord, we have served upon the
Mr. Shamul with you or without you? Yes, sir.
My lord, we have served upon the parties. So far as the one service, my lord, it is refused. Other is till today, my lord, it's inconclusive, my lord. My lord, take it up on Wednesday, my lord, by then it will be.
Learned counsel for the respondent submits that pursuant to the previous direction of the court dated June 17, 2025, comma, service of notice was attempted on the learned advocate.
No, advocate.
Appearing for the appellants, comma, semicolon. However, comma, the latter informed that she no longer had instructions to appear for the appellants, comma, for which fresh service was sought to be effected on the appellants themselves. Full stop. Next para. Learned counsel for the appellants seeks 2 days accommodation in order for the service to be completed. Full stop. Accordingly, let them attest and adjourn till June 25, 2025, when an affidavit of service shall be filed indicating the outcome of the service, comma, by the appellant, by the respondent. Thank you. Wednesday, same heading.
Nine, my lord, I am for the petitioner. My stay application, my lord, although my lord, my appeal was admitted, and there was the direction to my lord, submit the my lord, the special messenger cost that has been complied with the time. And my lord, since my lord, I could not appear before lordship, my lord, the stay application was dismissed for default.
Oh, restoration.
Restoration.
By an order, what is your, you're engaged in some other court or something?
No, my lord, I missed the list, my lord, missed the list.
By an order dated April 21, 2025, comma, the appeal had been dismissed for...
No, but stay application. Appeal has been admitted. First appeal has been admitted.
Stay application bearing can 1 of 2023 was dismissed for default. Full stop. You have complied with the other directions.
Yeah, of course, of course.
So next para, it was further directed in the said order that the appellant was to comply with the other directions regarding preparation of paper books in the meantime. Have you filed paper books?
No, my lord, the record has not admitted.
Acha. Next para, learned counsel appearing for the appellant submits that that learned counsel had missed the matter in the list on the relevant date, full stop. However, comma, as regards compliance of the court's direction, comma, it is submitted that special messenger costs have already been deposited.
Paragraph 2, my lord, I have stated, my lord.
It was deposited in time.
Yes, yes.
In time.
In time, my lord. The order was passed on, my lord, 22nd, my lord. I have deposited, my lord, on 24th.
Very well. Was deposited in good time. Full stop. Next para. Upon a perusal of the averments made in the application, comma, we are satisfied about the conduct of the appellant being bona fide, comma, since the postal requisites and special messenger costs have already been put in time, but due to non-arrival of the trial court records, comma, the paper books could not be filed as yet. Full stop. Next para. Also, comma, since sufficient reasons for the absence of the appellant's counsel on the relevant date have been made out, comma, Can 2 of 2025 is allowed, comma, thereby recalling the order dated April 21, 2025 and restoring Can 1 of 2023 to its original file and number. Full stop. Next para. There will be no orders to cost. Tarporer para. We make it clear that since none had appeared for the respondent as well on April 21, 2025, comma, we apply the principle embodied in Order 9, Rule 4 of the Code of Civil Procedure and dispense with prior service of the application on the respondent. Thank you.
But I have to serve upon the, my lord.
Can 1 shall appear in the list now. Where you will direct it to appear? The appellant shall serve. How many respondents are there?
Only one.
Can 1 of 25?
Yes.
The appellant shall serve a copy of Can 1 of 2025 on the respondent, indicating that the said application be listed in the monthly list of July 2025. Full stop. The appellant shall file an affidavit of service on the returnable date.
Yeah.
Can 1 the monthly list. আমরা allow করলাম কোনটা? Can 2.
One thing, I shall request my court officer to correct the advocate record. There is the one Partho Sarathi Chatterjee, not the Mr. Rafiqul Islam is the advocate and record.
This time, please give a proper slip so that it can be rectified.
Yes.
Just give up on a proper slip of paper, please give it. Otherwise, that will be copy pasted. উনি স্লিপ দিয়ে দিচ্ছেন শঙ্খ, এটাই করো। আগের বারটা তুলে দিও না, তাহলে ভুলে যাবে। এটা স্লিপটা নিয়ে যাবে তো তারা নাকি? তুমি সাইডে বসো, স্লিপটা নিয়ে চলে যাবে। Yes, next matter. Yes, Mr. Mahath.
In this matter, I am for the appellant.
Mr. Mahath, please take the microphone.
Last occasion, my lord directed me to file the affidavit of assets and to serve the respondents. My lord, I have prepared it. It has not been completed. Can you give me 3 weeks time? 3 weeks time.
Why so?
To serve.
Oh, to serve. You are filing it today?
Yes, my lord. No, I am not filing, but it can be filed, my lord.
3 weeks, very well.
3 weeks.
Learned counsel for you are for the appellant wife?
My lord.
Learned counsel for the appellant wife seeks further time of 3 weeks to comply with the order of this court by having the affidavit of asset of the wife affirmed and having it served on the respondent husband. For some next para, accordingly, let the matter stand adjourned till July 21, 2025, when an affidavit of service to that effect shall be filed by the appellant appellant wife. First up, how soon can you file it?
Well,
how soon can you serve it? Sorry.
Well, within 3 weeks, I shall serve complete service.
Very well. Ja, bolam tai.
Thank you.
11, my lord, I appear for the appellant, my lord.
Yes, Mr. Vardhan, what is the matter?
If my lord kindly sees my lord's last order, my lord. My lord, there was an issue as regards, my lord,
date of death.
Yes, my lord. Now, my lord, we had already filed the substitution application in the court below, my lord. I have taken instructions that has been filed. But there also, my lord, it will meet the same fate. So, my lord, for the time being, what I would be praying is let this matter go out of list. Let me exhaust the remedy out here and come back, my lord.
This arises from an injunction refusal.
Refusal of ad interim order injunction.
Learned counsel for the appellant submits that due to non-availability of the date of the deceased original respondent number 1, the details furnished in the application and the prayers made therein could not be construed to be complete. Full stop. Next para, it is submitted that the appellant has in the meantime filed a substitution application in the trial court as well, in connection with a refusal of injunction by which the present appeal arises. Full stop. Next para, since the outcome of the present application shall somewhat be dependent on the fate of the application for substitution filed in the main suit, let the matters go out of the list for the present, with liberty to the parties to mention for inclusion in the list as and when they deem fit.
In fact, my lord, on the last occasion, my junior told me that it had been filed, but we didn't have copies.
Now you have
Therefore, I restrained myself, my lord, because there was submission made at the bar that we had not filed.
Achha, very well. So now you
Yes, my lord, we got it, my lord.
take appropriate steps there. Otherwise, same
Same fate, my lord. I'm so
that
grateful.
suit has abated, then we cannot.
Then the setting aside abatement has to be followed and come back. my lord.
Otherwise, we have to dismiss
Yes,
it.
my lord. I'm grateful, my lord.
Respond.
Appellant, my lords.
Yes.
My lord, sir, kindly see the order passed by the division bench on 9th of September.
9th of September.
9th of September. So now, my lord, so now there is a restraint order passed by this honorable court not to remarry.
This is that application for final hearing.
So now in the meantime, my lords, the second marriage has been conducted by the husband.
After this order?
No,
Yes.
my lord, subject to your lordship.
My
My
lord,
lord, this is the second marriage, my lord. Special marriage registration has been done, my lords, on 16th of February 2025. My lord, I have a document, my lord. This is the document registration, and my lord, the social marriage has been passed, my lord.
Where is that document?
My lord, this is the.
You're filing an affidavit.
Lordship,
You
my
have to hand over copies to him
I
also.
already, my lord.
Why don't you hand over these copies earlier so that we can have a comprehensive hearing at one go?
My lord, he knows. এইটাই তো সে তুই কোনটা দিচ্ছিস কোনটা দিচ্ছিস এটা কি এটা আর আরেকটা তো দিয়ে দিলাম
ছবি, হ্যাঁ, এটা হচ্ছে রেজিস্ট্রেশন যেটা করেছিস।
and my lord, this is the registration document. I have, my lord, this I obtained, my lord, twice.
No, this application, strictly speaking, the order was till the next date.
But that is the, my lord.
What happened? You
But
did not mention the matter on that day.
I mentioned this matter, my lord.
Prayed for extension.
My lord, this my lord, this
They are at a technical advantage.
This is the technical fault. Because of that, I mentioned before the division bench having the determination, my lord, but in spite.
Just ask for extension.
My lord, that
Yes. What do you say?
My lord, this,
neither any application for extension was filed nor it was extended.
You knew about the pendency of
No, my lord.
Yes,
but my lord, the interim, subject to your lordship's correction, interim order was till 11 November 2024, and marriage was solemnized in 25.
This is very bad conduct. You knew about the pendency of the appeal. Knowing about the pendency of the appeal, how could you remarry?
Pardon me, my lord, but
you should have taken the leave of court before doing that. The intention was to take up the matter on 11th November. If it does not appear, it's not the fault of the parties.
Subject to your lordship's correction, my
Your
lord,
conduct is deplorable.
No application was filed, my lord, to that for extension.
Can 1 of 2024 is an application? Your divorce suit was dismissed in the court trial. Sorry, their divorce suit was allowed.
Degree obtained by the husband, my lords.
Can 1 of 2024 is an application for stay stroke a restraint order on the respondent husband from remarrying. Full stop. The appeal arises at the behest of the appellant wife against a decree of divorce passed by the respondent husband. Full stop. It is pointed out by learned counsel for the appellant that by an order dated September 9, 2024, a coordinate bench had directed the respondent husband not to solemnize marriage till the next date, fixing the next date for hearing on November 11, 2024. Full stop. However, the matter did not automatically appear in the list on the returnable date. Full stop. Learned counsel for the appellant submits that despite mentioning the application was not included in the list previously. Full stop. Next para. Learned counsel for the respondent husband submits that the specific restraint order in the order dated vide September 9, 2024 was for the respondent husband not to solemnize marriage till the next date. Full stop. The next date being November 11, 2024, comma, the said interim order expired on that date. Full stop. It is submitted that the appellant did not take any measures for having the matter enlisted or for having the interim order extended, and comma, as such, comma, the respondent husband was at liberty to remarry. Full stop. Next para. Upon hearing learned counsel for the part Achana, a supplementary affidavit is filed today, comma, on behalf of the appellant, comma, pointing out that the remarriage was contracted by the respondent on September 16, 2025.
No, 16 February 2020.
February 16, 2025. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find that although technically the respondent husband was not debarred from remarrying after November 11, 2024, comma, till which date, comma, strictly speaking, the direction on the respondent not to solemnize marriage was passed, comma, the intention of the coordinate bench in passing such order was definitely that the husband does not contract any remarriage in the meantime. Full stop. The court had restricted the order till the next date on the obvious impression that the matter would next be listed on November 11, 2024, full stop. The same having not been listed, comma, even in the absence of any visible endeavor by the wife to have the interim order extended, comma, the obvious conclusion would be that the appellant now suffers due to the deficiency on the part of the judicial mechanism in having the matter listed on the next returnable date. Full stop. Thus, comma, broadly, comma, the matter comes within the purview of actus curiae neminem gravabit. Full stop. Next para. However, comma, at this juncture, comma, we are not equipped any legal provision to declare the second marriage of the husband void or voidable as per the existent law, comma, since technically the marriage was solemnized at a period, comma, although when the appeal was pending, but there was no subsisting order of injunction. Full stop. Next para. Yet, comma, we cannot but mention the deplorable conduct of the respondent husband in contracting the second marriage in hot haste, comma, despite full knowledge of the pendency of an appeal against the divorce order, as well as being aware that an interim order was passed at the inception, restraining him from contracting such remarriage, comma, without the leave of the court. Full stop. Next para. We deprecate such action of the respondent strongly. Full stop. However, comma, in view of the second marriage having been contracted in a period where technically there was no restraint order, comma, Can 1 of 2024 has been rendered infructuous. Full stop. Accordingly, Can 1 of 2024 is disposed of as infructuous without any orders to cost. Full stop. Next para. However, comma, it is made abundantly clear that the respondent husband, having taken a calculated and deliberate risk by contracting remarriage during pendency of the appeal and having full knowledge of the previous order of ad interim injunction, comma, the second marriage shall be subject to the outcome of the present appeal. Full stop. Directions were passed for preparing paper books and all. Were passed?
No order.
Why are you nodding your head then?
My lords, no order.
The appellant shall put in due requisites. In view of appearance of the respondent husband through his learned advocate, comma, service of notice of the appeal on the husband is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Great.
Next. Yes, Mr. Giri.
May please your lords. My lord, the appeal filed by the defendant appellant before your lordship. The suit was filed by the plaintiff before the City Civil Court, 10th bench, my lord.
Mr. Bhattacharya, you are appealing on which of the respondent?
Plaintiff respondent.
1, 2, 3.
All the respondents. Sure.
Up to 4.
Up to 4. Yes.
Very good. একটা order প্রথমে record করুন। We find from the office report dated December 13, 2024 that Tolobana of rupees 4 had not been deposited along with written up notice forms by the appellant. However, in view of the appearance of all the respondents to the learned advocate in court today, the requirement of putting in such Tolobana and written up notice forms is dispensed with. The application is now taken up for hearing. What is the application for?
My lord, I have filed 2 applications. One, my lord,
The applications are now taken up for hearing. 1 and 2.
10/1/2024. But
Injunction as well as stay.
No, that application is infructuous because
Which is infructuous?
1.
Why?
Now the 2, say number 2 is a stay application.
This is against eviction decree.
Eviction degree.
Injunction was restraining them from evicting you, and now stay of execution.
Stay execution has already been filed.
Therefore, stay application.
Yes. Next day is 7th July 2025.
Eviction suit on the ground of?
One ground of trespasser, but I have taken the plea that I am the tenant, and subsequently I have taken the point I have the adverse possession. Because the tenancy was 1964. My grandfather and generation up to date. I am there and along with my father and uncle.
So the tenancy got converted to adverse possession.
Yes.
Great.
It's my plea. Now my plea.
This will be a novel proposition of law. This will be a revolution in Indian law as well as international law.
But according to your lord, according to my lord and the instruction.
We want revolutions, but this is also not a bloody revolution.
Oh, my lord, your lordship knows everything, my lord.
Not everything, but regarding this, all of us know everything.
Yes.
Regarding this proposition,
I
including you, Mr. Giri.
My
The peculiar, this appeal, there is nothing in the appeal, will dismiss this application. No prima facie case.
Well, I'm saying for your lordship, the tenant, initial tenant, my grandfather, deposit the rent to the original owner. Thereafter, my lord, 3 times the property was transferred to the different transfer.
Lastly to them.
Last now. He issued a notice to me that you are the tenant. Subsequently, he admitted that you are the trespasser. After receipt of the notice, I sent a money order. He refused to accept the same. As a result, he filed the suit for eviction, main copy, and permanent injunction. I have filed my written statement.
What was the reason why the appeal court, the trial court turned down, allowed the decreed the suit?
But decreed the suit that the date was not fixed. From which date my parents or I possessing the land by way of adverse possession.
No, what happened to your, you abandoned the plea of tenancy?
My lord, I have taken the point that tenancy.
Alternately.
And alternatively, I have taken the.
So what was the court's finding on your tenancy plea?
Tenancy, there is no
document,
no opinion. But I have filed the challan.
Opinion, Mr. Bhattacharya?
My lord, kindly comes to, my lord, page 2 of the impugned judgment. Kindly comes to page 2 of the impugned judgment.
If there is no opinion, then Mr. Giri has a case.
Yes.
There is no opinion.
Defense case.
Let him prove, show the opinion that will.
Yes, kindly see, my lord, the defense case. It starts, my lord. Kindly comes to, my lord.
Amended written statement.
Amended. Kindly comes to page 57. Page 3. Page 3.
Yes.
I'm placing, my lord, from the second paragraph.
Yes.
After demise of defendant's grandfather, Ranjit Haldar and Indrajit Haldar carried on the business in the name of Ranjit Haldar, a bidi and the tea hot the seller in the suit premises since long time, and the valid trade license.
Sounds good in this weather. The shop.
The shop, yes. Utility.
Hot tea and all this. Bidi may not, yes.
Tea. Hot tea is yes.
So what happened to the hot tea then? Let us see.
Then, defendant category stated that he is not at all a trespasser, but the son of a bona fide tenant, running business of as a tenant's son. Tenant's son, my lord, he at best, my lord, he's at best, my lord.
Tenant's son is a new status.
tenant's son is the new successor. He claims that
Or an abuse also.
grandfather was the tenant. Then let me place Milord.
Tenant's son. He could
Tenant's
have
son.
claimed to be a tenant.
He stated on 21st April 2017, the defendants personally made the plaintiff produce all the documents and requested to accept the rent from the defendant, but plaintiffs refused. He stated here that thereafter the defendant sent the rent to money by money orders, but the plaintiffs refused. He stated that the notice dated 25th July 2000 is not not binding. Defendants denied the material. Kindly see next paragraph is very important. At para 12A of the amended written statement, defendant took alternative plea that the predecessor of the defendants were not a tenant nor equipped with any rent received, is not and is no privity of contract with the landlord and tenant. The court disbelieved this. In the original written statement, your case is the grandfather was a tenant. Now amended written statement, when in cross
in the alternative, they say predecessor of the defendant were not a tenant.
Not a tenant.
In the first place, they did not produce any rent receipt of the grandfather also.
Only, Milord, what
you admitted in some things somewhere.
No, I am the subsequent, the fourth hand, Milord. It has been, Milord, transferred. I am the subsequent purchaser. My suit, Milord, is trespasser. My suit is not, Milord, on 2G. My suit is trespasser. In what capacity you are there? Now, Milord, kindly see the issue.
Then it goes on with the adverse person.
Then,
but
Milord,
if it's yes, was it dealt with whether he was a
yes,
tenant?
kindly see, Milord, page 6 of the impugned judgment, issue number 5, 6, and 7.
Respective share, no, that is dependent on adverse person.
No, kindly, I'll show to your lordship, Milord, what is the ultimate finding. If your lordship kindly sees.
Is there any finding regarding tenancy?
Yes. Tenancy is there.
Issue that they did not produce.
Yes. Page 5 of the impugned judgment, issue number 4.
Yes.
Kindly see the third last paragraph of that page in affidavit in chief.
Yes.
DW1 stated that they are in occupation of the suit property along with space in the veranda now attached with the room. He stated that his uncle Ranjit and his father Indrajit Haldar during the grandfather's lifetime entered into a suit room without any authority at least 60 years ago. He stated that at that time no obstruction was read regarding such occupation. DW1 did not place any record on to show that he is a tenant in the suit property. A tenant in the suit property. He referred the trade license issued by KMC and in the name of the grandfather, father, and himself. That was the only document.
Adverse person is
now, Milord, adverse position, Milord, kindly comes to, Milord, page 8 of the impugned judgment. What is the finding of the learned?
Page 8.
Page 8.
Yes, we are there. Para 2.
Yes, para 2. Kindly see, Milord, he did not unequivocally say in what capacity the predecessor in interest came into possession of the suit property. In the written statement and amended written statement, at one place he stated that his grandfather Vidubhushan Haldar was a tenant in respect of a shop room under Bijoy Krishna Ghosh for a monthly rent of ₹43. On the same breath, the defendant states that defendant or his predecessor were never a tenant but all along were trespassers. Now, this was the case in the amended written statement. Defendant neither could plead clearly on what was it or its predecessor status at the time of initiation of possession of the suit property. In affidavit in chief of also DW1 also stated that he remained in long drawn possession as a trespasser in the suit property.
Yes, you have seen the judgment. Yes, Mr. Giri. We are dismissing the appeal as well as the application. We are taking up the appeal itself. This point is involved. We are taking up the appeal as well as the application and dismissing.
My lord, regarding the adverse position in question, my lord.
Totally disbelieve, nothing to prove.
Generation to generation, I am in possession. They have admitted I am in possession. And my lord, the father and uncle was not party in the suit. They are in possession. Against me, the plaintiff filed a suit only.
Yes.
But there are father and uncle, they are running their business in hot tea stall.
You have not taken that point also. You have said generation after generation you have been in possession of.
In my written statement, can you see?
Show us.
Yes, I can see.
From the impugned judgment where it has been recorded, what is in your written
statement? Written statement, can you see page 19?
This is not the
amendment. If you kindly come to page 3 of the impugned judgment, internal page 3. You have stated after demise of defendant's grandfather, Ranjit and Indrajit Haldar carried on their business in the name of Ranjit Haldar.
Yes.
Ranjit Haldar, who is Ranjit Haldar? You.
Uncle.
Uncle.
No, I am the
uncle.
I am the son of
Acha, Ranjit Haldar, a biryani hot tea seller, such and such.
They are the son of Bhushan Haldar.
They are still alive.
They are still alive and they are there. They are
You have not taken any point of non-joiner of those.
Kindly see. Paragraph 2, I have taken the point. That was not considered.
What is that point?
Kindly see page 19. Page 19 in my written statement. The suit is not maintainable its present form, that as per caption of the suit mentioned just after the cause title plaint. The defendant stated that the landlord has no jurisdiction to try the instant suit. Only on small causes court of Calcutta has jurisdiction.
How is this material?
That next 3. The suit has been filed against the wrong person. As such, the suit is liable to be dismissed on the way. Wrong, but I am
wrong person, meaning saying non-person won't do. You have not elaborated this pleading.
Can you see 7A?
7A, yes.
7A, my lord, I have stated everything. 7A, everything, and document had already been filed in the exhibit.
Where have you stated that your uncle and father are still in possession with you? Shows that. You have given their history, how they purchased.
Well, I have stated in paragraph 7A, B.
You have described your father and uncle as your predecessors. Predecessors means who have predeceased you.
But they are in possession. Well, kindly see.
Where is that statement?
Well, last paragraph of the paragraph B. Last paragraph, my lord. The defendant's father and uncle, any time as such, the defendant's predecessor, Ranjit Haldar and Indrajit Haldar, the uncle and father of the defendant, would not know the real owner of the suit premises. The defendant stated after the demise of said grandfather, the defendant, the state Ranjit Haldar and Indrajit Haldar, and legal year, successor legal representative, have been carrying on business under the name of Ranjit Haldar, BD and Hot Trichala. Long time past.
7C you have stated at page 21. Ranjit and Indrajit have been, as legal as successor, have been carrying on business under the name of Ranjit Haldar and BD and such and such.
And the necessary paper, documents, and even in regular electric bills, I have submitted before the court below.
You have said you have been running business as a capacity of tenant's son.
My lord, my father is old. I am.
But if you give up the tenancy, then you remain only. You say you have been running business. You have admitted that you are running business in capacity of tenant's son first. Then you take an alternative plea that there was never a tenant. In your evidence, you say he was never.
I have taken the point that the father and uncle are the original tenant because my grandfather.
That is a different, because that you have waived subsequently in your evidence also. But you have not stated that Indrajit and Ranjit, they are also residing with you. You have stated that you are a son of the bona fide tenant and you have been running business in the capacity of tenant's son.
Kindly see E, my lord.
E, yes.
That on receipt of notice dated such and such from the plaintiff's advocate, the defendant personally meet with the plaintiff and produce showed all paper, document, and also request them to accept rent from the tenant. But they refused. Thereafter, the rent for the said tenancy was sent by money order. But the plaintiff refused to accept the same. The defendant stated that the notice served through the Sayak Majumdar Lane upon defendant is not at all binding upon the defendant. The defendant is the son of the Indrajit, who is one of the tenant in common.
But once you say adverse possession, there is no concept of tenant in common.
I have taken the point because the generation to generation since 1964, but the arguable point is there, man, because whether I am in adverse possession or not.
There is no argument.
Well,
no proof of adverse.
The learned court, come to a conclusion. No date was
induction,
fixed.
date of induction.
No date was mentioned from who, where, and when they are claiming the adverse. Because, my lord, the deeded parties never claimed, and the original owner never claimed. Now, the subsequent purchaser, the present plaintiff before your lordship, filed a suit for eviction, means profit, and and my lord, he has not made any application for recovery of possession under section 34 of the Specific Relief Act. So, my lord, the time, the ground is there.
Mr. Bhattacharya, only one thing. They have stated that their familiar tenants
No,
in common in respect of
Tenants, my lord, they kindly see, my lord,
tenants. Let us disbelieve.
original and the amended written
Tenants,
statement.
let us disbelieve. But this is the original at page 19.
No, original written statement. This is not the amended one.
Where is the amended written statement? Why haven't you annexed the amended written statement, Mr. Giri?
It is here, my lord.
This is a material suppression.
Yes, no, my lord. It is my fault. I have not annexed this, my lord. Your lordship kindly consider.
Then material suppression by you, not your client.
Yes, in my fault. But may I kindly see 12.
12A.
Give a copy to him also. What copy you hand?
Kindly see page 4, para 12A.
Defendant is in possession. Diametrically opposite. You cannot take this alternative view. Alternative please cannot be mutually exclusive with each other. Cannot be.
In other
They are mutually destructive, please.
No, my lord.
Mr. Giri, sorry, nothing.
My lord, one thing.
We won't keep these sort of appeals pending on this.
Correction, my lord. The rent receipts 1964 and till 2024-5, we are in possession.
Rent receipts were exhibited.
Exhibited before the court below. Kindly see.
Where is
My lord, I have annexed here.
No, not annexure will not do.
My lord, exhibited.
Where is it reflected in the impugned judgment?
Exhibited, my lord, in the court below. Kindly see. Page 24.
Exhibits 1 to 3, what were those? Those are there. Exhibit A to G, they are exhibits, what were those? Trade license and all.
Trade license and the
receipt was not
rent receipt in the name of Bidhu Bhushan Haldar. That is their case. Our grandfather was a tenant. Definitely Bidhu Bhushan Haldar's name is there.
But thereafter, no one come forward. The my lord, other transferees have not come forward. We are the tenant, we are the landlord, we are claiming the.
But if you take, who advised you to take this adverse person plea? You have demolished your own case of tenancy.
The court below the landlord advocate, my lord. I am not in a position to remark anything, my lord. I have asked my client why you have taken this point. But subject to the out of court, I am submitting before your lordship. And my lord, as and when we have taken the plea regarding the tenancy, the city civil court has no jurisdiction. Secondly, my lord, as and when, my lord, I have taken the point 12A by way of written statement amending the same, taking the plea amendment adverse position. Because generation to generation, it is, my lord, your lordship, kindly consider it. Generation to generation, and till there I am in.
Sir Giri, let us read out para 12A of your written statement.
I have seen it, my lord.
Let us read it out.
My lord.
You have said the defendant is in possession of the suit property through your predecessors, not a tenant, nor equipped with any rent receipt, following any privity of contract between the parties as landlord. The defendant is in possession of the suit premises without having any valid legal status as tenant, but for avoiding legal consequence as to the claim as rank trespasser. This is your written statement. That to avoid legal consequence as to the claim of rank trespasser, the defendant described himself as tenant, despite the real fact that neither he nor his predecessors was ever a tenant.
But some contradiction in the contradiction.
Some contradiction.
No, it is my pleading. It is my pleading.
Sorry, we are dismissing the appearance.
I am submitting one thing. For the interest of justice, your lordship.
That is precisely what we are thinking of.
Give some protection to my client. Give some protection. Because your lordship kindly consider the stability of.
Will dispose of the appeal and the application. Will record your prayer for stay of that judgment and will grant you 1 month stay. Go up in appeal before the Supreme Court. That is the only reason.
Yes, your lordship. 1 month stay, my lord, very poor person. Your lordship then, my lord, tell me at least 5 months.
What is tea biri stall is not very poor.
Tea stall, my lord, garam cha. Garam cha.
That can take you to the top executive leader of the country.
Yes, yes.
If that
But-
can be so, it's
but
not
we are
a
the
that
poor,
bad.
we are the poor person. My lord,
We
subject
don't
to
find any poverty anywhere.
nothing.
India is now
asked my
without
lord-
poverty.
my lord, I
All
have
poverty
asked my
eradicated.
client- I have
We are
asked
in a
my
golden
client,
utopia.
why you have come here? You could not pay my fee. Nothing. Only 200, 500 rupees. Very poor person. My lord, I confess the same.
Occupation, business.
Business maybe, my lord. Yes.
The suit property is in Amha Street.
Amha Street.
Tea business is Amha Street. We know what it is.
Your lordship knows nowadays this, my lord.
We might have had tea also there.
Tea, cafe. That may not have.
No, no.
Very well, my lord, your lordship, your lordship kindly.
Poverty, if you are poor, then take legal aid and go to the Supreme Court. We will grant you
interest
1 month.
of the- my lord, poor cannot get the law. Law is law. Law. My lord, your lordship can just above the law. Your lordship knows, my lord. Your lordship can give me some protection. 5 months or 6 months stay. I will go, my lord. I'll take last chance as your lordship desire, my lord. But otherwise, I will not, my lord, hand to mouth, my lord, only for the status to.
We'll grant a stay of the appeal period. We'll dismiss the appeal, but we'll grant a stay for 3 months. Let him go up.
3 weeks, not 3 months, my lord.
Months.
Right.
Should he supply you one of the grounds of SLP?
I do not know, my lord. He's
Supply
a
you,
beggar.
right?
I think he's a beggar.
Beggars don't sell tea in tea stalls.
Because he is not able
Mr. Giri,
to.
Mr. Giri, you can, your first ground will be that this was a date fixed for hearing of the application, but we are taking up the appeal also along with it. This will be your first ground in the SLP. You may get a relief there,
No,
other ground.
I am not taking this plea, my lord. I am praying.
Do that, we are asking you to.
I am praying before your lordship.
No, we'll
to,
dismiss.
to stay the execution case at least 5 months.
We'll dismiss the appeal and the application.
Yes.
We'll stay our order for 90 days so that you can prefer an appeal before the Supreme Court with legal aid. And in that SLP, take the first ground that today was a date for taking up the application, not the appeal. But we dismiss the appeal.
My time will not. My lord. My lord, one thing subject to correction. The execution proceeding be stayed.
You have done enough.
As your lordship
Well,
desire.
execution proceeding will stay for 90 days.
Yes.
After
Then
dismissing the appeal for preferring SLP.
Without
Heard learned counsel
your
for the
lordship
parties.
Your lordship can give me chance to file the paper book. Then your lordship here.
Heard learned counsel for the parties at length. Full stop. Next para. While hearing the application for stay, comma, we find that the scope of the appeal is extremely brief. Full stop. As such, comma, instead of unnecessary relegating the appeal to the paraphernalia of preparation of paper books and bringing of trial court records, comma, we decide the appeal along with the application on merits. Full stop. Next para. Upon such notice being given during hearing, comma, we hear learned counsel for the parties at length. Full stop. Next para. The short question involved in the present appeal is whether the appellant has even a prima facie case for hearing of the appeal, comma, since a mutually destructive plea of tenancy on the one hand and as adverse possession on the other was taken in the written statement by way of amendment. For some next para, the initial plea of the defendant stroke appellant in his written statement was that the defendant is the within double inverted son of a tenant, double inverted clause. Full stop. The defense case was premised on the alleged tenancy of his grandfather in respect of the predecessor in interest of the present plaintiffs stroke respondents. Full stop. The defendants even produced a purported rent receipt in the name of the said grandfather at the time of evidence. Full stop. As per the original written statement, comma, subsequent to the grandfather, comma, the defendant's father and uncle became tenants of the property. Full stop. An apparently contradictory plea has been set out in the defense in the original written statement to the effect that the defendant is within double inverted son of a tenant, double inverted clause, on the one hand, and that the defendant is a co-tenant with his father and uncle on the other. Full stop. Next para. Not stopping there, comma, the written statement was subsequently amended. Full stop. Next para. It will be relevant for the present purpose to quote paragraph 12 capital A of the same. তন্ময় paragraph 12 এটা এখান থেকে কোট করে দেবে। এইটা প্যারাগ্রাফ 12 এ এটা পুরোটা কোট হবে এখান থেকে এই পর্যন্ত। নেক্সট প্যারা। A bare reading of the said paragraph shows that admittedly the defendant within bracket as opposed to the defendant along with his uncle and father bracket closed is in possession of the suit property within double inverted through his predecessors double inverted close full stop thereafter comma fatally fatally to the original defense case comma it is pleaded that the defendant stroke appellant apostrophe s predecessor was not a tenant nor equipped with any rent receipt following any privity of contract between the parties as landlord and tenant. Full stop. It is stated that generation after generation the defendant has been in possession of the suit premises without having any valid legal status as tenant. Full stop. It is further stated, comma, boldly we may say, comma, that for avoiding the legal consequence as to the claim of rank trespasser, the defendant described himself as tenant, despite the real fact that neither he nor his predecessors was ever a tenant in the suit property equipped with any rent receipt issued by any owner of the suit property at any point of time, and as such, comma, the deposit of rent in the office of rent controller is equally not sustainable since a mere imagination. Full stop. Next para. By the said paragraph, comma, the entire original case of tenancy has been demolished by the defendant stroke appellant himself beyond recognition, comma, by claiming himself to be in adverse possession of the property through generations and clearly denying the original case of tenancy. Full stop. Thus, comma, even if any document was produced to show the purported tenancy of the grandfather of the defendant stroke appellant, comma, the same stood demolished by such statement in the pleading of the original written statement. Full stop. Next para. Being in the nature of mutually destructive, comma, the pleading of tenancy and adverse possession cannot go hand in hand. Full stop. Next para. Since the case of adverse possession was introduced later by amendment, comma, the trial court was not at fault in any manner in proceeding on the basis of the case of adverse possession. Full stop. A perusal of the impugned judgment clearly shows that upon consideration of the entire evidence at length, comma, the learned trial judge came to the obvious finding that the starting point of adverse possession could not be proved by the appellant, full stop, nor could the appellant prove in any manner, comma, by any corroborative evidence whatsoever as to the possession of the plaintiff defendant stroke appellant being hostile, comma, denying the title of the real owners and being for a continuous period without any disruption from the end of the original and true owners. Full stop. Next para. In such view of the matter, comma, and since the true ownership of the plaintiff stroke respondents have been admitted clearly in the additional written statement, comma, coupled with the fact that the plea of adverse possession could not be proved by any cogent evidence, comma, the learned trial judge was absolutely justified in decreeing the suit for eviction of trespasser against the appellant. Full stop. Next para. Thus, comma, we do not find any merit in the appeal whatsoever. Full stop. Accordingly, FAT 365 of 2024, FAT 210 of 2024, along with the connected application bearing applications bearing Can 1 of 2025 and Can 2 of 2025 are dismissed on contest without any order as to costs. Full stop. Next para. Dismissed on contest without an order as to cost, comma, thereby affirming the impugned judgment and decree dated October 1, 2024, passed by the learned judge, 10th bench, City Civil Court at Calcutta, District Calcutta, in title suit number 1600 of 2017. Full stop. Next para, interim order, interim order নেই কোনো, এটা দিতে হবে না. Next para. Decreed drawn up হবে এই পর্যন্ত.
মানে regarding the
এরপর next para. After the above judgment is passed, comma, learned counsel for the defendant stroke appellant seeks an order of stay of operation of the above judgment as well as the execution case levied by the plaintiff stroke respondents in connection with the decree impugned in the appeal. Full stop.
title execution case number 1.
In order to give ample opportunity to the appellant to prefer a challenge against the above judgment and decree, comma, we grant stay of all further proceedings in title execution case number 116 of 2024 pending before the 10th bench, pending in the City Civil Court. It is pending, it generally is pending before the registrar.
No,
The
10th bench. Learned Civil Court, 10th bench.
Execution case also.
Yes.
Execution case number 116 of 2024 pending in the City Civil Court at Calcutta in connection with title suit number 1600 of 2017 for a period of 90 days from date. Full stop. It is made clear that in the event no challenge is preferred against the above judgment and decree within the said period and stroke or any ad interim order of any order of stay stroke injunction is passed within the said period, comma, it will be open to the decree holders stroke plaintiffs stroke decree holders stroke respondents to continue with the execution case. Full stop. In such case, comma, it is expected that the learned executing court shall proceed with and dispose of the execution case as expeditiously as the business of the said court permits.
Grateful lords. Your lordship
Judgment decree. Next.
দেখে দিন ম্যাডাম এটা দিন ম্যাডাম দেখে দিন নাম্বারটা
অনেক দিয়ে দিন. Next ম্যাটারটা করুন.
Grateful lords.
My lord, I beg to appear for the appellant. My lord, on the earlier occasion, I ought to have apprised your lordship of the earlier order dated 19th of December 2023. My lord, my learned senior friend had submitted that the opposite party, contesting opposite party number 2, had transferred her share to the opposite party number 1. Now, your lordship would kindly take the report dated 17th of June 2025, whereby, my lord, there was some difficulty with the wakalatnama executed. My lord, since he has transferred the share, my lord, the notice of appeal may be dispensed with regard to the opposite
Who
party
has
number.
transferred to 1?
2 to 1.
So therefore, this defect will
Not necessary.
yes.
But these are
What
my
is this?
affidavit in opposition to the application for injunction.
Had we directed you to serve copy on the respondents at any point of time?
My lord had directed me to give a notice to my learned senior friend yesterday.
Only to Mr. Only to the
Yes,
respondent number.
so far as this correction is to be done.
No, respondent number 2 we did not direct.
Initially, there was my lord direction for service.
Yes.
Notice was served. We appeared. My lord.
No, respondent number 2 was also served.
Yes.
Yes, respondent number 2 was also served. Your lordship would kindly take.
You are appearing only for 1.
I filed the vocalatnama, but
Oh,
there,
oh, oh.
my lord, the signature is different. My lord, the Bholanath Das and
Acha,
Bhumbo
fair.
Das Bibor.
Can you file a corrected?
File a program, but he is suffering, my lord. He is not in a position to sign. If your
No.
lordship kindly allow me 2 weeks time, I can file the vocalatama.
We'll take up the dispose of the application in the meantime. We'll direct it.
My lord, this is an application for expeditious hearing. My lord, I have been appointed by the Legal Services Committee.
Injunction application?
Yes, injunction application, my lord, is pending. Your lordship would kindly peruse the order dated 19th of December.
There are 2 applications.
Yes, 2 applications.
One is for injunction and
One
this
is for injunction. 19th of December, your lordship will find, my lord, they have expressed their categoric intention that they do not seek to.
Oh, that. Yes, Mr. Mahato, you won't transfer any further. We can
I
record.
am not in a, my lord, I have stated in my opposition that the allegation that I will make a multi-storied building, that I have denied. And so far the transfer, I have disclosed, my lord, that it is, my lord, at page, I have already transferred some portion after the dismissal of the probate proceeding.
One has transferred.
Both, 1 and 2.
This is against dismissal of a probate application.
Yes, grant of probate has been turned down.
Mr. Mahato, we shall restrain both of you from making further transfers or changing
Yes.
the nature and character.
All the parties will not make any transfer.
Where is
But-
status quo regarding all
But
parties?
only difficulty is, my lord, I'm repairing as necessary.
Lord, let him come up
We'll
with a
give you
proper.
liberty to take
Man,
up an
man,
application, giving a schedule, and
man.
that will be in our order also, that liberty. You will use a reply to this?
To the
Opposition?
my lord will not record that, my lord.
No, we'll record it in a different way. Affidavit in opposition filed today be kept on record, full stop. Since the application can be disposed of without further directions of reply, comma, we take up the application for hearing. Full stop. However, comma, it will be deemed that none of the allegations made in the affidavit in opposition are admitted by the appellant. Full stop. Next para. The appeal arises from the dismissal of a probate of an application for grant of probate made by the appellant. Full stop. Next para. Since arguable questions of fact and law are involved, comma, can 1 of 2023 is disposed of by granting an order of status quo, directing both parties, directing all the parties to maintain status quo with regard to further transfer, comma, alienation and or encumbrance, creating encumbrance in respect of the suit property and or alteration in nature and character of the suit property till disposal of the appeal. Full stop. Next para. The learned advocate, having instruction to appear for the respondent number 1, shall file a corrected vakalatnama in terms of the office report dated June 17, 2025, within a fortnight from date. Full stop. Next para. Can 2 of 2024 is an application for expeditious hearing of the appeal. Full stop. In view of appearance of both the respondents to the learned counsel, learned advocate, comma, service of notice of the appeal on the respondents is dispensed with. The trial court records, comma, along with the original will, comma, which will be kept apart with the Registrar General, comma, shall be called for by special messenger at the cost of the appellant. Push up you are through legal aid.
Yes.
Since the appellant is appearing through the legal aid services of this court, comma, the legal services authorities of this court shall ensure that special messenger costs for bringing the trial court records are put in within 3 weeks from date. Full stop. Next para. Upon the arrival of the trial court records and the service of notice of the same on the learned advocate for the appellant, comma, the appellant shall prepare and file the requisite number of paper books through the High Court Legal Services authorities within 8 weeks thereafter. Full stop. Next para. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
And to file the application for repairing if necessary.
Yeah, thank you. It is made clear that nothing in the above order of status quo shall prevent either of the parties to make proper application in the event any repair is necessary in respect of the suit property. Full stop. Next para. Comma, by enumerating the current condition of the property and the exact nature of such repairs as required. Full stop. If such an application is made, comma, the same will be taken up by the court by the bench having determination without being prejudiced unnecessarily by the order of status quo.
I'm good.
Item number 15, my instruction is not to proceed with the appeal. This is
The
my
appeal.
instruction, my lord.
After seeing Mr. Kolol Bosu appear for the learned counsel for the appellant submits that the appellant does not want to proceed further with the appeal and the connected applications. Oh, applications were disposed of. No,
Application
one is
pending.
with the connected pending application. Full stop, next para. And a written instruction filed in court today by the learned advocate for the appellant in that regard, comma, be kept on record. Accordingly, FMA 536 of 2024 along with CAN 1 of 2024 are dismissed for non-prosecution without any orders to cause. Interim order, if any, stands automatically vacated. Thank you.
Still, my lord, I'm the appellant, my lord.
16 paying for not today.
Why?
Mr. Orin Chakraborty, another court.
But may I submit, my lord, on 18th of March 2025, my lord has passed an interim order. I am enjoying an interim order, my lord. That interim order was not being properly maintained by the respondents. That is why I filed CAN 2 of 2025 for appointing a special officer for taking the symbolic possession of the open premises in the suit premises. On last occasion, my lord had passed an order on 21st May 2025, passed an order for directing them to file their oppositions against both the application. And no opposition has been filed till date.
What about the opposition? What is your instruction on that?
No instruction.
Initially, an ad interim order was passed.
Yes, on 18th of March. Yes, injunction.
An adjournment is sought on behalf of the respondent numbers 1, 5, 6, 7, 8, 9, 10, and 12. Full stop, next para. Learned counsel for the appellant stroke petitioner points out that initially an ad interim injunction order was passed on the prayer of the appellant, but thereafter the appearing respondents having not complied with the same comma, an application was filed for appointment of a special officer for taking possession of the symbolic possession of the property, suit property. Full stop, next para. It is further pointed out that directions for affidavits were also given. Full stop, however, comma, today a bare adjournment is sought on behalf of the appearing respondents without any affidavit in opposition being filed. Full stop. As a last chance to the said respondents to file such opposition and appear and contest the applications, comma, the matter is adjourned for the day and the time for filing affidavit in opposition is extended till tomorrow. Full stop. It is made clear that in the event further adjournment is sought on behalf of the said respondents on the next occasion when the matter is called on for hearing and stroke or the said respondents remain absent, comma, the matter will be proceeded with ex parte in the absence of the respondents.
Deeply obliged, deeply obliged.
Please inform Mr. Chakraborty that you have passed this order. Without them, it will, and the opposition last date is tomorrow. If you don't file, then you are without opposition.
Deeply obliged.
Yes, Mr. Mukherjee, what is the matter?
17, 18.
You are for the other side?
17, 18, 19, 20.
17 to 20 একসঙ্গে বোর্ডে দেখিয়ে দিন। Yes, Mr. Mukherjee, what is the matter?
Same group. My lord,
Land acquisition?
Yes. My lord directed us to, my lord, file supplementary before vacation. We are ready, my lord, but we could not be informed. This senior citizen of 19 and 20.
So when should you keep it for filing the supplementary?
No, we could not be informed because their senior citizen 19 and 20. This is our all group in one.
Yes.
So my lord,
they're seriously ill.
My lord.
So when should you keep it? Tell us.
I am giving, my lord, I am tendering the advance copy.
No, when can you file it? Up to how long?
2 weeks.
2 weeks.
Yes.
Give them advance copies of. So we'll pass directions for affidavit. Opposition we directed? No. We had not directed.
Yes.
We are directed. We'll extend those timelines. Learned counsel appearing for the appellant in all the matters submits that although the matters are connected with the self-same acquisition proceeding, comma, due to illness of some of the respondents, comma, all the supplementary affidavits could not be affirmed. Full stop. However, comma, the appellant shall supply advance copies
by tomorrow
of all the proposed supplementary affidavits by tomorrow to the learned advocates appearing for the respective respondents.
I am appearing for the state.
Yes, to all of you it will be served. State and the different.
Appellant will.
So next para. Accordingly, we extend the time for filing supplementary affidavit for a fortnight from date. Full stop. Advance copies thereof shall be served on the learned advocates for each of the respondents by tomorrow. Full stop. Composite affidavit in opposition to the application and the supplementary affidavits shall be filed within July 21, 2025, that is a fortnight thereafter. So next para, reply thereto, if any, shall be filed by July 28, 2025. The applications shall be listed together for hearing in the monthly list of August 2025.
I'm grateful to your lordship. কিন্তু এগুলো দেবেন না।
Give a copy on the state also.
State কি কেন?
Acha,
MDA was a part.
all our deficit court fee matters. We'll also direct that.
Yes,
The appellants shall put in the deficit court fees in all the matters within a fortnight from date.
KMDA was a party, my lord.
Section 5.
Last,
Whoever is the respondent, all respondents will be served. That is why you said the respondents respectively. State, KMD, you, the land losers. We have a different, I have a different division bench. So we'll have to rise.
Yes, Malad.
Yes, Mr. Chair.
I am appearing on behalf of the appellant.
Right. Matrimonial?
Yes, Malad.
Matrimonial?
Yes, Malad.
Yes.
Matrimonial. Sir. By this application, the appellant prays for direction upon the learned trial court, Malad, to send the trial lower court record.
So early hearing of your
Yes, Malad.
your suit has been dismissed, divorce suit.
My suit has been dismissed.
The present application is one. The present application is one for expeditious hearing of the appeal. Full stop. Can 1 of 2025 is disposed of by directing the appellant to put in the postal costs and due requisites for service of notice of the appeal on the respondent, comma, within a week from date, full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week. Stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. No rest to cost.
Grateful, Your Lordship.
But I am for the appellant.
Respondent.
This is a case where, Lord, the money suit filed by the husband against the wife. They are in an acrimonious relationship.
No divorce suit.
Divorce proceedings is pending. But Lord, this is on the basis of an independent transaction and acknowledgement the suit was filed. This has been dismissed. So, Lord, the appeal is against dismissal of the suit.
Rightly dismissed. What sort of a suit is this?
Lord,
what have you asked for now, Mr.
Lord, nothing. No.
Early hearing, this
Early
was the
hearing,
usual
this
direction.
was a call for the record.
Very well. The present appeal has been preferred by the appellant husband against the respondent, by the appellant husband against the dismissal of a suit filed for money by the appellant against the respondent wife. Full stop. Next para. Heard learned senior counsel appearing for the appellant as well as learned counsel for the respondent. Full stop. Next para. Can 1 of 2025 is disposed of by is disposed of in view of the appearance of the respondent through her learned advocate, comma, service of notice of the appeal on the respondent is dispensed with, full stop. Can 1 of 2025 is disposed of by directing the appellant to put in special messenger costs within a week from date, full stop. The trial court record shall be brought by such by special messenger. Next, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records to the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. No rest to cost. Prothomei affidavit of service filed to be kept on record.
Much okay.
Thank you. Great. Thank you.
For the applicant petition.
Yes.
Application not 8 days delay, my lord.
8 days.
68 days. My lord.
68 days. Server appearing for the first time. Serve a copy and serve copies. What is the other application? Appeal is against what?
My lordship, another application is injunction application.
This arises from?
Arises from counterclaim has been lordship filed by the appellant petitioner, my lord, appellant defendant, my lord, which has been dismissed, my lord. Thereafter,
The suit has also been dismissed. Then you have preferred only one appeal?
we are the defendant.
You're the defendant. What was the suit for? And your counterclaim was for? Declaration of your exclusive right. But if you don't challenge the partition suit has been declared preliminary form.
Preliminary form, my lord.
This is a challenge against the counterclaim. But if you don't challenge the partition preliminary degree, then this appeal will be rendered infructuous ab initio. That remains then. Without an appeal, this appeal is not maintainable, but no effective relief can be granted.
Pass, my lord. Thereafter,
If the preliminary degree stands, even if you win this appeal, then what will be the effect? That decree will remain. It will be contradictory. Advise your client immediately for the second section 5 application. The appellant shall serve copies of Can 1 of 2025 along with Can 2 of 2025 on the respondents. Serve on all the respondents because it's a partition suit. On the the others are pro forma. on the respondents as well as pro forma respondents, indicating that the applications shall be listed together for hearing in the monthly list of July 2025. An affidavit of service shall be filed on the next returnable date in that regard. Do the needful immediately, otherwise this appeal is, meaningless. Yes. Yes. You are for the respondent.
Yes.
Mr. Rai, you are for the appellant, obviously. Yes. What is the matter?
But,
Your application.
my application.
This is my affidavit in opposition, my lord, to the application for modification filed by my learned friend. My lord, I have also filed an application for contempt, my lord. That is also appearing as item
So
number.
let us dispose of the modification first, because otherwise the contempt.
But,
yes.
I have prayed for a modification of your lordship's order on the 22nd May. Now, my lord, I
The
have.
order is also annexed here to the application.
No, it's not been.
We will look into our record.
Yes. No, my lord,
12th May.
yeah, 22nd May, where your lordship had directed for
Yes.
3 days, that the child would be sent to the father's house, and she would stay there up to Sunday in the
Yes.
morning, and then be returned. Now, my lord, the child is showing signs of resistance. About this. Of resistance.
Please,
And
please,
she had
please
to
take the
be-
microphone a bit
yeah.
above, Mr.
She had to.
What is the age of the child?
7. And now, my lord, she is a girl child, is a daughter. Now, why I have said this is that let the child be examined by your lordships.
7 is not intelligent preference age. That is a difficulty.
That
We would have
we-
definitely on the last occasion also, because you
Your
had
lordships kindly.
repeatedly been flouting the order of court.
No, that is ostensible. That is ostensible. I'll have, if he presses the contempt application with it, I will file a reply to that. I'll file a reply to that. But here, if your lordship.
But did you take the child every time?
We tried. Once she fell ill, she could not. I sent message to the father that please come and visit your child at the.
What about the
nursing
other
home.
times, other occasions?
And that is
You had brought only
that
once.
was the only occasion. After that, my lord, they have filed. After that, that was the 30th. 30th, the contempt is not there. They don't complain of any contempt because I took the child there. She resisted. Then there was a scuffle. And
So there was resistance in the mind of the child. That's
yes, my lord. The main thing is this: if your lordship's kind.
So Vasu, she's residing with you. 7-year-old child is entirely dependent on your instruction and your training.
Your lordships will relieve us of this because of the fact that I'll tell you, lordship, he's the brother-in-law of my client is an advocate. She's practicing in the lower courts, and she has greatest respect for your lordship's orders. But if your lordship's kindly.
Then you'll have
take
to
it
release
upon-
on personal ground if she has great respect for us.
She has.
But she'll lose the respect if you direct contempt.
I will file my reply. After that, if it's ostensible contempt.
No,
then
but
your
what?
lordships
Where
will
is the
relieve
scope
me.
of modification?
Will it, your lordships will kindly, if I can produce the child, your lordships will kindly talk to her. This will resolve the issue. If this litigation,
you have
and
annexed
both of us, my lord,
you have annexed a discharge certificate saying
yes,
panic
yes,
attack
she
also.
was there. She was there, and there is also page 49, page 40. My lord, she had sent a message to the father that please come and see the child. He didn't go. He didn't go to the nursing home. He could have verified as to whether his child was ill or not. He didn't take that opportunity. My client is here, Millard, and also, Millard, they have also agreed.
This arises in connection with the divorce proceeding.
Yes.
And
you obtained a
No,
divorce.
my lord, the divorce, I filed a suit for divorce that has been negated. I prepared
that's-
an appeal.
We
my
are
lord,
also
there,
ready.
my lord,
We
I
are
have
also
filed-
ready to.
My lord,
Was there any arrangement in the trial court regarding
nothing,
custody
nothing,
visitation?
nothing.
No, my lord,
Millard,
it
we
is
can settle this
suit
issue.
was not contested. My lord,
Mr. Rai, can we send this to mediation? Subject to the contempt, we'll keep the contempt pending.
My lord,
Because a 7-year-old
Madam,
child, we are not competent enough to,
no, my lord,
They have
not,
also
not
agreed.
professionals to deal with
but
the.
the way he's she's flouting the order. My lord, I must indicate before your lordship. My lord, I must indicate, my lord, on the day, my lord, your lordship directed on 22nd May to produce the child on 23rd. Now, my lord, a telephone call was made. My lord, I prayed leave from your lordship to place this telephone call. Now, my lord, telephone call was made. Yes, I shall hand over the child to you, but she has drawing classes, abacus classes, dance classes. You have to bring the child to the classes. Then there was some altercation. Now she says, whatever may be the order of the court, I shall not produce the child to you.
Mr. Rai, we appreciate fully what you are saying, but there may be, it may be prompted by the child's,
Kindly see the
it will create trauma in the child.
The way, why she was admitted to the nursing home. Kindly see the way. She has not, the child didn't say anything to the doctors that I am suffering from this or that. Now, kindly see what the mother says to the, what the mother informed. Kindly come to his application, page 21.
Yes, 21.
Now, kindly come to left hand side. Left hand side.
Yes.
Sudden outburst, may I lead? Sudden outburst and violent reactions regarding news of some difficult judgment within bracket court explained to her by her mother. So, this is pre-planned things that has been done. The mother explained the child that you have to go to the father, and the child become furious. Am I to believe that? Now, the doctor has recorded that under what circumstances she was admitted. On the instruction of the mother, this has done. The child was admitted. It is apparent from the note.
Your Lordship will let us try to have a mediation, or we'll keep a child. We'll refer it to some child psychologist for this mediation.
On 30th, this is on 23rd. On 30th, she made a story that she brought the child to my place, and there was a scuffle. There, kindly see the between opposition. Kindly see my
opposition to this
to this application.
Yes.
What she done, she didn't brought the child at all. She was not present at all in my place. Lost a diary on the next day.
Sir, right. Throughout the divorce proceeding, you did not ask for this visitation.
Yes, I have.
What happened to that?
I have. The learned trial judge directed the child to produce in the office of the district legal service authority. Now, that has also been plowed. I have indicated in my application can 1. I have indicated that. Now, kindly see, although the child was not brought on 30th, on the 1st June, she lost an FIR. And kindly see the FIR. I want to place this FIR.
Mr. Rai, we are being very candid. Since it's a child of 7 years, we are telling you because we have to have an interaction with the child otherwise. Yes. But see, we are not competent people to have an interaction with a child of 7 years and understand what plays behind this. We may get an inkling, but let this be referred to a child psychologist as a mediation, for mediation.
But the child
keep the contempt pending and let us
yes.
Before sending her to jail, let us explain.
I'll explain. The contempt is a separate proceeding altogether.
The advantage on your part will be, Mr. Rai, if she is referred to a child psychologist for mediation, both purposes will be served. There will be an assessment also.
Yes.
Per se, there will be an assessment by the child psychologist also regarding whether this neurosis is arising out of being tutored by her mother, or it's now inherent in her. Absolutely. Maybe due to previous training.
Very well, Malad.
Obviously, she was in custody of the mother. There has been some tutoring.
Malad, on the
but forcing the child and
kindly, Malad, on 30th, after 23rd, 30th was the next date.
Yes.
She made an attempt. She said that she produced the child to my residence. There was a scuffle. Myself, my brother, my parents, all of them heckled her. And kindly see the FIR, what the case she has made. It's I could not think of this case.
Where is that?
I have lost annexed the FIR.
Which page?
That is that page. If I kindly come to page 22.
Yes, that is a complaint.
That is the complaint. Now, I am skipping over there. Now, মানে 22 last 4-5 lines. I went there in this Friday on 30th May for complying the order, but my minor daughter was crying brutally and she did not leave me at that time. My mother-in-law, Indrani Gupta, and my husband, Tirtha Gupta, was started quarreling with me and said, তুই ছাড় আগে মেয়েকে, তুই বেরো, তুই না বেরোলে আমরা তোকে ঘাড় ধাক্কা দিয়ে বের করে দেবো, তুই থানায় গেলেও কিছু করতে পারবি না। I was extremely helpless at that time because my daughter had a previous hospital history regarding anxiety because she was admitted before few days at hospital. Regarding this issue, my daughter clung to me and did not want to leave me at that time at Nilachal. I immediately understood that she was showing the same symptoms of anxiety and panic for which she had been hospitalized earlier. My husband, ignoring the fact that my daughter was crying and clinging on to me, tried to snatch my daughter from me. He was helped in this task by my brother-in-law, my father-in-law, and my uncle-in-law. When I tried to protect myself, they outraged my modesty. They have pull up my hair severely, scratch my right hand and beaten up by belt. My husband repeatedly kicked me in the lower abdomen, my breast and private parts. My husband Tirtha Gupta this is important. My husband Tirtha Gupta and my father-in-law and brother-in-law touched the private part of my minor daughter brutally and said, ওরা ওখানে চেপে বসিয়ে রাখ আর নড়াচড়া করতে পারবে না, মামা করা বের করে দেবো তোমার বজ্জাত মেয়ে। I am asking whether is this possible? An 81 years old grandfather and 78 years old grandmother, and I am the father of the daughter. This is the allegation, and this is a POCSO and I have to take bail. It's a nasty allegation against the father, and this is a deliberate way to avoid this court's order. Deliberate. Now, Mr. Shanal is saying something else.
I'm not saying anything else. Your Lordship will kindly come to page 40 of my application. I'm not saying anything else. Page 40. Page 40.
40 of what?
Of my application. This is written to the father. 23rd. If he wanted to verify as to whether his daughter was ill or was he all right.
Was there a reply to this message?
No. Comply with the court's order. That was the thing. And if your Lordship sees page 39, addressed to my learned friend here. Addressed to my learned friend.
Why you have addressed to me?
Because
Why?
you are
What for?
Because he is the in-law, brother-in-law of my client.
Now, my lord, with regard to this,
Yes,
my lord,
I have not said anything. I have not said anything.
I didn't went there because, my lord, once,
If your
my
Lordship
lord,
sees the
once I
contempt
was,
application,
my lord, once
if
I
your
was
Lordship
called
sees
on, my lord,
Just a minute.
that she has broken up.
Who is the brother-in-law of your client?
He's,
Mr. Rai?
yes. He's a brother-in-law.
Mr. Rai will release this one person.
My lord, if at this stage the matter
The
is
allegations
released, my lord,
against-
if at this stage, my lord, the
Some
matter,
other bench will take up. We
now,
personally
my
know
lord,
you, there are
this,
allegations
my lord,
against you.
my lord, if
I am not confident that I will not be
She was
biased in
practicing
your
as a
favor.
junior as well.
I'll not be biased that I'm already biased in your favor because I feel that you could not do it. So if the bias is in the mind of the judge has a notion that he cannot do justice, should not reveal them.
why he is taking my name?
No.
Why he is taking my name?
But you're,
In order to avoid this court?
no.
Why he has not? Why not
any
let him
other court
answer?
would
Why
be
he has
as-
flouted the order?
Any
the
court is
father
as good as the
wanted
other.
He could have gone there.
Any court is as good as the other, Mr. Rai. So let us I am already feeling prejudice that I feel that you could not do it. So if I feel that I am not confident that I would be able to do justice in this matter, I'll release it on my personal grounds. The
Well,
affidavit, release
well,
it immediately and send it to the Honorable Chief Justice for assignment.
now,
Assignment
so,
is done by the Chief Justice generally by 24 hours.
now, my lord, so far as the contempt is concerned, my lord,
I'll reply to the contempt. I'm ready.
Content under normal circumstances had to be heard by the same judge.
Yes.
But we'll request the Chief Justice to assign it also, subject to what the Chief Justice says.
It's an ostensible contempt. There's nothing. It's created.
The affidavit in opposition filed against you may be correct, Mr. Rai. We are not saying you are incorrect. That may be one of the reasons for putting you in, but we don't express any opinion on that. Affidavit in opposition filed
deliberate attempt to flight the order.
to Can 3 of 2025 be kept on record. First of next para, during the course of arguments, comma, it is pointed out that learned senior counsel that one of the counsel appearing for the appellant is a relative of the respondent. First up, in the application for modification bearing Can 3 of 2025, comma, certain allegations have been leveled which touch upon the alleged behavior of said counsel. Full stop next para. Even in the affidavit in opposition filed to the application today, comma, we find from the annexures that a complaint has been lodged, comma, inter alia, comma, against said learned senior counsel. Full stop next para. One of us within bracket Bhattacharya J bracket closed, comma, being comma to the being very well acquainted personally with learned senior counsel appearing for the appellant, comma, is not confident that he will be able to do proper justice in the matter, comma, since even in the perception of one of us within bracket Bhattacharya J, comma, there might creep into the judgment an element of sympathy for learned senior counsel due to such prior acquaintance. Full stop. As such, comma, we deem it fit, comma, for the ends of doing proper justice between the parties, comma, to release the matter on personal grounds on one of us within bracket Bhattacharya J bracket closed. Full stop. Accordingly, let the matter stand released, comma, including the contempt application, full stop, comma, from our list, full stop, next para. We request the Honorable the Chief Justice to assign the matter, comma, including all connected applications, comma, as well as the contempt application, bracketed, although under normal circumstances, the court passing the order, comma, if available, comma, is required to take up such matter, bracket closed, to some other bench. Full stop, the file be sent immediately to the office of the Honorable the Chief Justice for such purpose. We are sorry, Mr. Rai, I don't feel I'll be unbiased in this matter.
But, we were thinking of finishing this off, but he is what to do with it. I was thinking that the divorce should be granted and let them be. That's what I was thinking. Anyway,
yes. Next.
For the hello, dam for the appellant, my lord.
Yes.
My lord, the appellant, my lord.
Talks of settlement going on.
Yes, my lord.
Going on and on and on. We'll add 2 ons if it has not yet.
My lord, the parties have entered into a terms of settlement, my lord.
You have.
Yes, my lord. And in can number 2, my lord, we have a joint affidavit filed by the plaintiff and defendant number 1.
Just please give us the background once.
Yes, my lord.
What is the other side? He has to be present.
She was supposed
You
to
have already arrived at a settlement, Mr. Chakraborty,
yes.
in this matter.
Yes, I have annexed the copy of the terms of settlement, my lord. My lord, may I just state the background of the matter, my lord? The suit, my lord, pertains to a flat, residential flat at a posh area in Alipur. My lord, what had happened, my lord? The father of the plaintiff number 2 and 3, who are partners of a LLP firm.
Mr. Hussain, can you please give a notice to your other side and bring him so that we can pass an order? The appeal can be disposed of.
Appeal can be disposed of, my lord.
So please bring your other side so that we can pass an order there. Otherwise, some there will be a change. We have seen matters where we have done that and change of advocate, and the other side comes and
My lord,
files a
I
recall
will
application.
serve a
Please
notice,
bring
my lord.
your other serve a notice. We'll keep it tomorrow only.
My lord.
Should we keep it tomorrow or day after tomorrow?
My lord, then my lord, I'm told, my lord, her advocate is coming. My lord, may
Pass over.
pass over the matter for
Very
the
well,
time
pass
being.
over.
my lord.
Whenever he comes, just mention.
Yes, sir.
Pass over.
Grateful.
I'm opposing the application.
27, 28, my lord, both my appeals.
Yes.
And my lord, the stay petition, there was a direction, my lord, for filing of affidavits. In one, my lord, they have filed, in the other, they haven't. And there
That
is,
has not been admitted as.
no, both, my lord, your lordship.
No, what has not been admitted, Mr. Chakravarti? First appeal, regular first appeal.
My lord, yes, my lord, there has been a delay. With regard
Let us hear her, then we'll come. Please take it.
There is a section 5.
Ms. Devanaji, please take it a bit. Yes.
Yes, so, my lord, I'll tell your lordship, my lord. There, initially, we filed a, my lord, appeal, which is the first item, my lord, from the decree of eviction.
All right.
There, my lord, we had a counterclaim. So, your lordship, my lord, gave me
Counterclaim declaration of tenancy.
declaration of tenancy.
That also dismissed. Against that, you have filed a first appeal.
Second first appeal,
Yes.
which is the next item.
Yes.
Now, my lord, second first appeal, there was a delay. Then, my lord, there we filed a section 5, my lord, which is scan number 2.
Right.
My lord, the direction was given by your lordship.
Service.
Affidavits in that. My lord, I am told, my lord, no
I
affidavit.
have no objection, my lord, for condonation of delay.
Section 5. So,
Yes,
section
my
5 you are allowing, then taking up. Regarding the first appeal, there is no section 5.
There is no section 5.
So, can 2 will first.
And there was an order, my lord, in the first appeal, where your lordship had stayed the impugned order. I'll tell your lordship.
We'll immediately go to that first. Let us just allow the second, the can 2. Can 2 of 2025 has been filed for condonation of delay of about 88 days in preferring FAT 163 of 2025. Full stop. Should we record your consent or make it an order of the court?
My lord, may not record, my lord.
Upon hearing learned counsel for the parties, we find sufficient explanation for the delay having been furnished. Full stop. What is the explanation, by the way?
My lord, to retrieve the records, my lord, from the court, and my lord, when your lordship, my lord, gave me that permission to file the appeal, from then that there was no delay. But
Well, can 2 of 2025 is allowed on contest, thereby condoning the delay in preferring FAT 163 of 2025. Full stop, there will be no arrest to cost. The said appeal be deemed to stand registered and admitted. Full stop. Next para, can 1 of 2025 filed in connection with FAT 48 of 2025 is now taken up for hearing. You have filed the opposition today. Can 1?
I have already
previously filed.
Yes.
You are filing a reply to that.
no reply, DHO. We haven't, my lord.
You won't use.
Not required.
Achha.
But one thing, my lord, I must point out. My lord, the order of 16th April 2025, in both the appeals, my lord, your lordship had granted a stay, my lord, till disposal of this can 1.
The other appeal stay is meaningless because partition, your counterclaim has been dismissed. So stay of a dismissal does not mean anything. Your eviction suit stay is the more important thing.
Yes, correct. Yes.
My lord, condition may be imposed, my lord.
Yes, yes. What is the ground of eviction?
Lord, ground,
Trespasser.
they are saying.
So we have to look into that affidavit in opposition, but if you don't use a reply,
I will use a reply.
they have to use a reply.
Have to.
Otherwise, we'll accept their opposition.
I will use a reply, my lord, in the first appeal, which is
Yes. Mr. Chakravarti, you have used an
we have
opposition.
given opposition only in the second first
The
appeal.
second first appeal.
Ah,
Yes, we have that only.
yes. No,
163.
I think I have given.
That is meaningless. In fact, SAT 1, can 1 of 2025 in respect of the first appeal will dispose of, there is no scope of grant of stay.
My lord,
But you have to use your opposition to the can 1 of the first appeal regarding eviction. Otherwise,
163.
yes.
In respect to 163.
We will extend the time for filing opposition to.
And we have filed opposition 163.
163 opposition, what is the meaning of that? That is not even against an eviction degree. He has something up his sleeve. You're fishing out affidavit of in opposition. Use an opposition to that. We are disposing of the first can. There is no. That stay order is continuing.
So there is, my lord, on 16th April, stay was still disposal of can.
That cannot. Let that remain.
Yes, and but then subsequently your lordship has passed. I was not there on that day, my lord. On 7th May, it says, my lord, stay till further order. 7th May, interim order granted earlier
Further order means order on that application.
till 30th June. It specifies here.
Till 30th June.
Yes. First order there was already till disposal.
That will extend till disposal.
Yes, grateful, my lord.
আচ্ছা বললাম যে ক্যান we will take up can 1 of 2025 ওটা তো হয়ে গেছে তারপরে deemed registered and admitted তারপর
we file opposition to
FAT 163 of 2025 is now taken up for hearing. Full stop. We find the short backdrop of the case is that the respondents in both the appeals filed an eviction suit against the appellant, to which a written statement and a counterclaim, seeking declaration of tenancy of the appellant, was filed. Full stop. By the impugned judgment and decrees, the eviction suit was decreed, against which FAT 48 of 2025 has been filed, and the counterclaim was dismissed, against which FAT 163 of 2025 has been preferred by the appellant. Full stop. Can 1 of 2025 seeks an order of stay of operation of the decree dismissing the counterclaim, full stop, since no effective purpose would be served by granting any stay of operation of a dismissed counterclaim, we dispose of can 1 of 2025 within bracket in FAT 163 of 2025 bracket closed as infractuous as not maintainable. Full stop. Next para. Insofar as can 1 of 2025 is concerned, we have already granted an ad interim order of stay. Full stop. Although initially the order was passed till disposal of the application, subsequently the same was made limited. Full stop. Next para. However, since the question of imposition of occupation charges as condition of stay arises, in view of the nature of the appeal being a challenge to an eviction decree, on the prayer of learned counsel for the respondents, we extend the time for filing affidavit in opposition to the said application for a fortnight, Mr. For a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. Can 1 of 2025 within bracket in FAT 48 of 2025 shall be listed for hearing next on July 15, 2025. Full stop. The interim order of stay granted in respect of the stay of operation of the said eviction decree shall continue till disposal of the application. Full stop. It is, however, re-emphasized that the question of imposition of occupation charges and, if so, quantum of the same from the date of the impugned decree is kept open for being decided at the final disposal of the application.
Lord, one thing, my lord. This is FAT 43. Your lordship has renumbered as FAT 163 of 2020. 125.
FA 125.
125. FA 125.
যেখানে FAT 48 of 2025 বলেছি ব্র্যাকেটে
125
রিনাম্বারড হয়ে অ্যাপিয়ার করছে লিস্টে বোর্ডে কি দেখাচ্ছে 27
125
FA নাম্বার কত
FA
125 ব্র্যাকেটে FA 125 of 2025 এটা হচ্ছে রিনাম্বারড অ্যাজ কথাটা ব্র্যাকেটের মধ্যে রিনাম্বারড অ্যাজ হ্যাঁ ওটাই যেখানে ইউজ করছে ওটা করেছে হ্যাঁ বা প্রথমবার যেখানে ইউজ করছে FAT 48 ওখানে ব্র্যাকেটে রিনাম্বারড অ্যাজ নতুনটা তারপর নতুনটাই দিয়ে যেতে হবে ঠিক আছে? Right.
Item number 29. The affidavit service.
I have the instruction, my lord, to appear on behalf of the respondent husband.
My lord,
Appellant respondent, yes.
Yeah,
What else?
My lord, I have been served with a copy of the opposition as per your lordship's direction, my lord. But today I have come back. I was out of town, my lord. So I require, my lord, the 2 weeks time, my lord, to file my reply there to my lord.
Section 5.
Section 5, my lord.
2 weeks time to file your reply.
Reply, my lord.
Well, file your opposition. The affidavit in opposition filed today be kept on record. First of all, on the prayer of learned counsel for the appellant, comma, the time for filing reply is extended for a fortnight from date. The applications shall be listed for hearing next on July 9, 2025. Wednesday.
Great.
Thank you. Hey, Mr. You have to give another copy. Affidavit in opposition, 1 copy.
I'm sorry, my lord. I'll just hand up to your lordship and hand the copy. In course of this day, my lord.
Do that.
I'll just do that. In course of this day. দিদি ওটা দিয়ে দিন আমি একটা কপি দিয়ে দিচ্ছি দুটো কপি একসাথে in course of the day my lord I undertake
Do it quickly.
Yes, yes.
We are not recording anything. We have recorded your file.
Item number 30.
যদি না ফাইল করে এগুলো আমাকে বলে দেবেন তাহলে অর্ডারটা সই করব না হ্যাঁ সরি yes Mr. Mushu what is
But I am appearing on behalf of the appellants.
You are for the respondent?
My lord, I am representing the opposite party number 1 and 2. 1 and 2.
1 and 2.
But service was done accordingly, my lord. In the last occasion, my lord.
1 and 2 are the plaintiffs. So what is the suit for?
Suit for partition. Injunction was initially granted. After that, it was vacated on 19th of December without hearing me, without granting an opportunity of being heard to me, my lord. 20th December reincorporated.
Why vacated?
Vacated on the reason that, my lord, they have not filed the requisites. So on the subsequent occasion, my lord, after vacating under Order 39 Rule 4, they have the learned court has, with greatest of respect, my lord, again reincorporated.
Not exactly 439 to A itself.
Even then, my lord, if they wanted
imposition,
to,
yes.
yes, my lord.
The
It
imposition
cannot be
without
done.
why do you say without hearing you? It was not a date fixed.
No, my lord.
Not a date fixed.
No, my lord. It was not a date fixed. We appeared. Although we appeared, my lord, they have filed a 151 application, my lord. That 151 application was allowed. If my lord kindly comes to the impugned order at once.
What is the date of the impugned order?
My lord, the date of the impugned order is 20th of December.
Right. Let us see that.
Yes, my lord. Just give me a moment, my lord.
Yes. We are looking into the memo. So.
Yes, my lord. My lord, before I proceed, my lord, there is a Section 5 application as well.
What is the delay?
Delay is, my lord, I have mentioned it as 27 days, but actually the delay is about my lord, the 117 days. Because, my lord, because the order was passed under 151, I had filed a civil divisional application that I have withdrawn. After I have gone through several judgments of this honorable court, I have gone through all those judgments and I understand that this is actually.
No, but is the appeal maintainable before this court? The value is undervalued. The valuation is 80,100, then below 1.5 lakhs. So it's maintainable before the district judge.
I have not checked that up. It's my
That's
fault.
the office report, so that's correct. We are
Yes.
holding it to be not maintainable immediately so that to save you further agony.
Very well.
And you have to add days to your
Very
Section
well.
5 again.
Very well, my lord.
We'll give you liberty to take back the certificate copy.
Very well, my lord.
We find from the office report that the appeal is valued at rupees 80,100. Fullstop as such, comma, as rightly pointed out by the stamp reporter, comma, the appeal is not maintainable before this court due to lack of pecuniary jurisdiction. Fullstop. Accordingly, FMAT Thank you. 137 of 2025 is dismissed as not maintainable on the ground of pecuniary jurisdiction, with liberty to the appellants to prefer a properly constituted appeal before the appropriate court having jurisdiction. Full stop. Leave is granted to the learned advocate on record for the appellants to take back the certified copy of the impugned order upon furnishing photocopies, a photocopy of the same for the records. Full stop. Can 1 of 2025 is also disposed of accordingly. This will be sent down to the office. Please do it from the office,
My
taking
lord,
back and all.
I will.
Thank you.
Grateful, man.
Thank
you. And my lord, if it be your lordship's pleasure to just add one line to consider the section 5 application liberally.
Section 14 has to be considered by the next court. We cannot do that. Since we don't
if,
have,
if my lord kindly observes
we
that.
don't have determination, we cannot.
Very well.
Without determination, Mr. Mushi, no, we cannot do anything.
Grateful. Lord.
Thank you.
I'm grateful.
Thank
you. The appeal is from Lord, an order of dismissal.
This is, yes, appeal has been admitted.
No, this is the first time it is appearing. No,
So-
there is an application. The application is different.
First appeal.
This is the first time it is appearing. The application is really inconsequential, my lord. It was, my lord, taken in
Experience
third
of
article.
hearing. What is the appeal against?
The appeal is, my lord, from an order of dismissal for default of a suit for mutual divorce on absence of one of the parties. Now, my lord, the question which really I would like to urge before your lordship is whether, my lord, the lack of
13B.
consent, 13B, my lord, whether the lack of consent or, my lord, the withdrawal of consent by one of the parties is, my lord, fatal to the application for
yes, fatal.
13B, my lord. There perhaps, my lord, perhaps I can show something, my lord. I have
13B
come with, my lord,
both-
one.
13B is based on consent. If both sides don't.
The language, the distinction.
That
in
is why the timeline is given.
the distinction in the language which I have come to find from one of the one Rajasthan High Court judgment is, my lord, lack of consent.
Persuasive value, we are not persuaded.
My lord, that's true, my lord. Their judgments
No,
in
no.
under 142 first, if your lordship kindly allows me, my lord.
142 is not applicable.
It is not. My lord, if
Order
your lordship-
23 is not applicable. Held
That
by
has-
court 7. You know it very well.
But 23 has been compared.
Don't waste the time of,
Kindly allows me to place the judgment once.
not us, but this court.
But kindly allows me to place the judgment once. My lord, it is persuasive value. It has got persuasive value. But
No, we'll
the
dismiss
reasoning
the appeal
might,
itself as
the
not.
reasoning might, my lord, appeal to your lordship. The reasoning might appeal to your
We'll
lordship.
dismiss the appeal and the application together.
My lord, if your lordship kindly allows me to place the judgment once, my lord, the reasoning might appeal to your lordship.
You have
Even-
the judgment.
I have a copy of the judgment. It is from Indian Canon, which I was really not willing to place, my lord.
No difficulty, but if there's a judgment,
My
how
lord, the
many judgments
paragraph-
do you have?
I have, my lord, one copy, my lord, the paragraphs on match in any case. My lord,
No,
the
only
issue-
one judgment you are citing.
Only one I will cite. My lord, there are others I will not because they are under 142, which has been followed and referred to here, and which is the analogy has been also followed here. In my lord,
Don't have another copy of this judgment.
But these Indian Canon, my lord, the paragraphs on match. If your lordship kindly allows me to come back tomorrow, my lord, I can, or my lord, the day after tomorrow, if your lordship kindly.
On the prayer of the appellant, let the matter stand adjourned till tomorrow. Come back with
the day
ample
after
copy.
tomorrow, if your
No,
lordship-
no, tomorrow. Why tomorrow? What is
My
it?
lord, second half, I have, my lord.
This will be taken up in the first half.
In the first half is the difficulty. Lord. If I
No,
can-
whenever it is taken up, it will be taken up. We will be there. You don't have that matter throughout the day.
I'll then try to verify their virtue.
No. Tonight you do your homework.
Lord, I have. That I have. I have.
Adjourn for on the prayer of the appellant, the matter is adjourned for the day. Only one.
Very good. As your lordship.
For you, that is sufficient.
As
Yes.
your lordship. As your lordship. Yes. I'm so deeply obliged, my lord. So deeply obliged.
13B तो प्रश्न ही नहीं.
My lord, I appear on behalf of the plaintiff appellant, my lord.
I'm the respondent.
Try करो देखो. Exactly.
I'm the respondent.
Yes.
My
And
lord,
you are the
lordship
appellant,
reason your
obviously.
lordship
Yes.
Directed me to file the pleadings, my lord. Plaintiff WS depositions, documents filed by the defendants and plaintiff.
Condonation was allowed. This is
my
injunction. Yes, you wanted to rely on pleadings and documents. That's why you are asked to. You have exchanged the documents between yourselves. This is your for the appellant.
Lordship.
So these are your documents.
Lordship.
You are relying on these also. No other documents. Very good. Yes. Please move the matter. Injunction. What is the appeal against? Remind us.
My lord, the suit for partition and partition suit was dismissed on the ground of partial partition and a defect of.
Please use the microphone properly.
My lord, the suit was dismissed.
Suit was for partition dismissed.
Lordship. And my lord, on the ground of partial partition and a defect of parties. And to my lord, on the last occasion, your lordship desired to know the pleadings. My lord plained. My lord, subject matter of the partition is 2.48 decimal land. My lord, plaintiff is the sister and defendant is the brother. In between two, and there is no other co-sharer in the suit for subject matter of the suit for partition.
Why was it held? It is bad for non-joiner of parties.
My lord,
Non-joiner of whom, according to the trial court?
My lord, may I?
My lord, the heirs of
No, let him finish. Yes.
Heirs of.
You take your seats, both of you. We'll hear you. Yes.
My lord, originally the plot of land was purchased by the father and mother jointly, and my lord, the father transferred his entire share to the daughter, and mother.
Daughter means you.
Lordship, and mother transferred his entire share to the son. My lord, the partition in between son and daughter.
But there was no partition, not demarcated portions.
Demarcated portion also. This
Their shares or demarcated portions?
Demarcated portion also.
According to you, demarcated portions.
Lordship.
Very well, then.
My lord, may I?
Demarcated portions, then where is the question of partition?
My lord, the partition in between demarcation of the parents.
Father and mother were jointly
purchased the property.
The absolute owners of the property.
Lordship.
Father gave his share to you, mother gave her share to him, the respondent. Son. So then you file the partition suit.
Lordship.
What is the finding of the court? Why is it bad for non-joiner?
Yes, my lord.
Who is to be joined
Because
according to the court?
The heirs of the father.
There are other heirs also.
My lord, they do not have share. They do not have interest.
No, there are other heirs.
Yes, my lord. Other
How
heirs.
many other brothers and sisters?
My lord, 2 sons, Narayan Chandra Mandal, Vishwajit Mandal, with 3 daughters. 2 sons and 3 daughters and wife. And my lord,
if you go on doing squats, you will have better leg muscles. Nothing else. Take your seat.
my lord, the property was transferred by father by a deed of sale, and mother also.
You say that total share of the father was given to you.
Yes.
Total share of the mother was given to her.
Yes.
Therefore, nothing remained for
Yes,
the
ma'am.
other heirs. That
And
is
there
your
is-
case.
yes, ma'am.
Why
There-
was it disbelieved by the trial court? What was the finding of the trial court on that?
My lord, this is not the inherited property. This is the purchased property.
Oh, inherited property means father and mother had other properties also.
No, only 2.48.
No, we are asking you what is the ground on which your suit was dismissed? What was the finding of the trial court?
Yes, my lord.
What was held against you?
Lordship.
We are not asking your version.
Lordship. Then, my lord, I'm placing the.
You don't know. You have not gone through
Yes,
the
my
impugn
lord.
judgment.
Yes.
Tell us
Yes,
what
my
is the
lord.
reasoning of the trial court for
My lord,
disbelieving you?
Chain deeds were not produced. One, and
It's held that you failed to establish title of your parents.
yes, my lord. Chain deeds were not produced, and my lord, the and the heirs of the father was not added.
Which portion of the judgment?
Lordship. My lord, the page 6 of the judgment. The chain of deed is not filed before the court to rest upon the averment of the plaintiff. The
Middle, second paragraph.
First paragraph, page 6 of the judgment.
Hmm.
The subsequent document filed by plaintiff without the basis cannot be acted upon, even though the matter is admitted by the defendant. Plaintiff only files the deed of gift and sale deed by which she claims her right on the suit property devolved from Purnachandra Mandal to herself. The deed being number so-and-so reveals the transfer was effected in respect of 2.4 decimal out of 16 decimal. It is argued by the plaintiff that the property is situated under municipality. My lord, then my lord, the last. My lord, the last paragraph. It is argued by the defendant that the defendant erected house over the suit plot after taking the loan from the bank. PW1 admitted in her cross-examination her father has not made any construction over the suit property. PW1 admitted that defendant acquired the property from her mother. It is the gift deed
and another is deed of sale. Both the deeds are in respect of the same property. No
You
evidence-
produce one deed of gift and another sale deed.
Sale deed. My
Both
lord,
executed by your father.
Lordship, my lord, at the first time, my lord, the deed of gift was executed.
After that, where is the
After
question
that,
of what the
he
sale
was
deed?
tortured by the defendant, and he again on the due to not acted upon, my lord, he has executed another sale deed.
Regarding the same property?
Same property.
In their favor?
Lord, in favor of the plaintiff. That is daughter.
You are the daughter?
Lord.
So you tortured her so that
No,
he executed?
father was tortured by that son. That is the defendant, sole defendant. Again, he executed deed of sale.
Father had already executed a deed of gift in
Yes,
your
my lord,
favor.
this is valid. This is
We
valid,
don't
my lord.
understand. If they tortured, then he should have executed in their favor. They tortured and he executed in your favor.
Yes, my lord. Son tortured.
We are feeling like torturing you.
Yes, ma'am.
Really, on the racks. Medieval period.
And my lord, the persons who
Let us
do
go
not
to
have
the
that
judge.
prayer.
Acha, let us hear. Please take a seat. Yes. What do you do? You are probably justified. Yes.
According to their plaint, amendment number 6.
Give us their case as well as your case, both.
Okay.
Their version also. They say that a portion was given to them by the father, father's portion to them, mother's portion to you.
Yes.
So cross gender. Father gave to the daughter and mother to the son.
They are
It will be easier for us to remember.
They are claiming that.
Their claim, yes.
Yes.
What
But
was the finding of it?
But no one can execute two deeds for the same property for a single person.
No, you tortured, therefore he executed another deed.
There is no evidence as such, my lord.
My lord, the
And
No, please take your seat. Yes. Let them complete.
this is already admitted by the
But
plaintiff.
if there are two deeds,
Hmm.
one of the deeds, the first one will take effect. Why not? Unless you prove that it is void or manufactured or something like that. You don't have any such case. So we'll take the first deed and he has title then. She has title then.
First deed was a gift deed.
Gift deed, she has title.
Gift deed. PW2 was the attesting witness on the gift deed, who is Lokhi Ghosh.
What did she say?
He also she also admitted
That?
in her cross-examination in page number 7 of the
What does she admit?
that the share of the property of her father is lying vacant. She claims that all the brother and sister are having shares in the property of her father.
Her saying does not count.
And
The documentary evidence prevails over oral evidence.
one more thing,
But she was an attesting witness in the deed.
but they did not confirm the signature of her before
an
the Karne trial court.
How should they confirm it? Prove it.
Exactly, they did not.
Registered deed.
But according to Evidence Act Section 68 of the Evidence Act, they are.
What do they have to do according to Section 68? Attesting witness, one attesting. Only sister was produced as attesting witness and she went against them. Very well, the gift deed goes then. Because it was not proved under Section 68 by one of the attesting witnesses. Understood. Sale deed, how do you get over that? That's also registered deed.
Sale deed, the PW1
Yes.
also stated in his cross-examination. 1 minute. Value of the sale deed is 3 lakh. Value of the sale deed is not 3 lakh. Then I shall not file any document of transaction of such rupees 3 lakh. I shall not file document to show in which account it was paid. There is no consideration amount paid for a sale deed.
Then an arguable question has been made out by them. Arguable question is there. There is a registered sale deed. Presumption of correctness is there unless you disprove it.
But
Where is the question of partial partition? 2.48 out of 16 decimal was transferred, but that was the only property of the father, of the parents, wasn't it?
But
Total property purchased by your parents was 2.48 decimal.
2.48. And total, the plot measuring totally, am I not wrong? That is 16 decimal.
16. You are not wrong, 16.
16 decimal.
But if 2.48 was your parents were the owner of only 2.48.
Hmm.
Insofar as your parents are concerned, 2.48 is their entire property.
Hmm.
That the father's share has been transferred to him. Why should the 2.48 purchased by the parents were also undemarcated?
Yes, but
The 2.48 decimal purchased by your parents,
yes.
that was also undemarcated with the rest of the 16 decimals.
In
Then probably the other co-owners would also come in.
Exactly.
What exactly? We are saying, you are saying exactly, you are not arguing.
And PW1 also admitted that Kakoli Karmakar is also alive.
We are not interested in any Kakuli Gorkar unless we know who she is.
The owner of the whole plot was the owner of the whole plot. We bought 2.48 from Kakoli Karmakar.
No, it is from the discussion, it is not clear. It is clear to the court there are no other unpartitioned co-sharers in Inspector Sutra about whom the court is not in a position to form any opinion. তাহলে opinion না form করলে তুই dismiss টা করলি কি করে? What is apparent and can be safely held, partition cannot be ordered, putting sole reliance on the description. এটা বললো না যে 2.48 যেটা কিনেছিল সেটা undemarcated. Have you annexed the sale deeds?
My lord, yes, my lord, on the can 2, my lord, I have annexed the sale deed. My lord, in between gift deed and sale deed, there is a deed of cancellation also.
The deed of gift was cancelled.
Yes, my lord.
Why? What is the logic behind cancelling the deed of gift and executing a deed
My
of
lord,
sale?
because of torture, and he was, my lord, again.
If he tortured,
Yes, my lord.
why should he execute in your favor? If I torture you
Yes, my lord.
to give a property, you will give it to me. Why to the Justice Kumar? She tortured. I mean, he tortured. Here also the
That is
gender.
what-
That's the
and, my
difficult.
lord, at the instance of the defendant.
The
my lord.
respondent tortured.
Yes, my lord, defendant, respondent.
Respondent tortured.
And he and the
And
father.
upon that torture, father executed in favor of the appellant.
Yes, my lord.
If I torture, it will be given to me. Why to you?
Yes, my lord. After that, my lord, a cancellation deed was executed by father. Then deed of sale.
They tortured him into giving in executing a deed of sale in your favor.
Lordship.
There is no such civil court order on
Yes,
the
my lord.
cancellation
The
of
defendant
deed
also
and
filed
all.
a suit in another suit for, my lord, the suit for title
That
and
is
injunction,
pending.
and also, my lord, the cancellation of 2 deeds, and that suit was dismissed, and my lord, appeal was also dismissed.
That is pending, my lord. And in page number 6, plaintiff also confirmed that judgment, it is stated by the plaintiff in her cross-examination that her mother and sister are alive and she has not implemented all the co-sharer of entire 6 anna share in the plot. She further stated that she will implement them. So from the statement, it is clear there are other co-sharer left who have not been implemented in the shoot. This is admitted.
Any
by
deed
the
was produced by you to show that the mother transferred her share to you.
I have
What?
Xerox copy of the deed.
No, no. Did you produce in the court below? There is no reference to that.
Yes, my lord, I have. Yeah, I have.
There is no reference to that.
Filed before the court, my lord.
Where is that?
And my lord, and
9749 deed number.
Where is the
page number
the trial court does
55.
not refer to any such deed. Which page?
Page number 55.
No, trial court does not refer to that. Where is the reference of the trial court? Internal page of the impugned judgment to that deed in your favor? He produced it or you produced it? You produced it.
Yes.
Exhibit A.
Yes, exhibit A.
So exhibit A shows that a demarcated portion was sold to you by the mother or her share only. Where is exhibit A?
Yes,
Among
my lord.
this bunch is that exhibit A
34 to
there?
40.
Yes, please.
Page 34 to, my lord, page 34 to 40
Of this bunch?
of this bunch.
34 to 40, 40 nothing ends.
34 to 40 is the deed where
34 to
Shri
40.
Chandra Mondal had bought the property from Kakoli Karma.
No deed ends at 40. 40 is the pat in the middle of a deed.
55 number page, my lord. Page number 55.
Kakoli was the original owner.
Kakoli
She sold to your parents.
Yes.
Yes, madam.
Let us see what she sold. Then we are granting injunction sufficiently arguable. You have argued so long, that means it's arguable. What injunction have you sought?
My lord, not to transfer.
Not to
transfer or alienate.
transfer.
And my lord, there is a can 2 also an application for
Can
additional.
please addition of party that will be
My lord, the
additional evidence will be heard along with the appeal. We'll direct you to file opposition.
Let's see.
And one more thing, my lord. Narayan Chandra Mondal is constructed a house.
Narayan Chandra Mondal is him.
Narayan Chandra Mondal is the
You.
respondent who constructed a house by arranging loan from Bandhan Bank and
I've already
Baba
constructed.
Shojana. Yes.
No further construction. No further construction. Where what you have already constructed is there.
And
we are restraining you from making any further change and change in the nature and character.
He blocked the ingress and egress of the plaintiff land, my lord.
What is that prayer?
My lord.
You have constructed a house over the entire property.
No.
Only 1.24 decimal of the
You
property.
cannot have a right of ingress and egress to his house.
Exactly.
You cannot have a right of ingress and egress to his
Exactly.
house.
They are blackmailing us.
Plaintiff's house.
Don't
Plaintiff's
blackmail
land.
them. We'll restrain you
They-
from blackmailing.
They are blackmailing us, my lord.
What amount are you paying for that? For the blackmail? Monthly?
They are blackmailing us various way.
Like?
They are trying to dispossess us. They are trying to possess in our builded house.
That is not blackmail. Section 5 you have allowed already.
On the last occasion.
Upon hearing learned counsel for the parties, we find a sufficiently strong prima facie case having been made out for hearing the appeal on merits. Full stop. Accordingly, the parties are directed to maintain status quo with regard to change of nature and with regard to further change in the nature and character of the suit property, as well as in respect of further transfers, alienation, and or encumbrance and or creating encumbrance in respect of the suit property in favor of any third party till disposal of the appeal. Full stop. Can থ্রিটা বললাম এটা না and 3 is allowed বলিনি এখনো আচ্ছা can 3 of 2025 is disposed of accordingly without any orders to cost. Full stop. Para can 2 of 2025 is an application for production of additional evidence. Full stop. Let the same be listed for hearing along with the appeal as and when the appeal is ready for hearing. Affidavits, if any, shall be exchanged in the meantime. Please exchange affidavits to order for Rule 27. Next para. In view of the appearance of the sole respondent through his learned advocate, service of notice of the appeal on the respondent is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Please keep it with you. If it is a part of the record, then it will come in the paper book. We'll look into that. Next. পাসওয়ার্ডটা এসছে দেখে দিন পাসওয়ার্ড দেখে
Lord,
gratefully Lord.
We talk to the other side, my lord. She cannot come today, my lord.
We'll keep it tomorrow.
My lord, day after tomorrow.
Day after tomorrow. On the prayer of the appellant and in view of non-appearance of the respondent, let the matter stand adjourned till 25, June 25, 2025.
Great, my lord. We will serve.
Bring her, we'll pass an order. Yes.
Great.
Well, I am for the appellant, my lord.
Appellant, yes.
The limited issue whether the father will get the right to visit his child. My lord, on the last occasion, your lordship asked me a question whether there was an application made
In the
before
trial court,
learned
yes.
trial court. I took the instruction, lordship. The instruction is negative. There was no application made.
You had not made.
Visitation right separately before the trial court. However, lordship, after reading the judgment,
Why should you be given the visitation right
lordship,
after
it
so long?
should be in order to maintain the balance and the completion of the justice, end of justice.
What
Father
ends of
must not
justice?
be prevented
How
from-
long was the suit pending? When was the suit filed?
My lord, this suit
It was your suit for divorce.
It was my. It was my suit for suit under Section 8. It's Act 8.
Act 8.
Act 8. My lord.
So in that you did not ask for visitation. You filed an
not-
application for guardianship and custody.
Yes, my lord. So
That is strange.
even lordship, I have gone through-
Have you served?
I have served.
Oh, you
my
have
lord.
already
On the
served.
last occasion, I have furnished the affidavit to serve
The
his lordship.
Son is of 13 years of age.
13 years
So we
of
want to hear the son then. We'll direct the respondent to produce the son.
My lord, that because
That will be easier.
Because on the date of admission, your lordship was pleased to observe that since son is of 13 years of age, so there is an intelligible preference which could be.
Learned counsel for the appellant, comma, in his usual fairness and on instruction, comma, submits that no application for visitation right was made by the appellant in the trial court. For next para, taking into consideration such fact, comma, we are of the opinion that before changing the status quo in that regard and directing visitation, comma, we are required to have an interaction with the minor child, comma, who is of 13 years age and is and has attained the age of having intelligent preference. Full stop, next para. Accordingly, the respondent mother shall produce the minor son of the parties for an interaction with the court on July 7, 2025 at 4:30 p.m. First up, the appellant shall communicate a server copy of this order to the respondent at the earliest and file an affidavit of service to that effect, comma, in order to ensure compliance.
I beg to appear on behalf of the husband respondent. Well, I am appearing on behalf of the wife appellant, my lord, pursuant to your lordship direction passed on last occasion. I am filing my affidavit of assets and the affidavit in composite affidavit in reply to their affidavit in opposition to my alimony application and affidavit of assets. Copy has already been served upon my lord. This is, my lord, my opposition and asset.
One minute. They'll be confused and it will be a mix up. With a wife, that's. Thank you. Yes. What is their income according to them?
Well, according to the document disclosed by my learned friend, his monthly salary slip, it appears that he is drawing 70,100 and something odd.
70,100 per month.
Per month.
Per month.
This is, my lord, their document.
What is the alimony you have asked for?
That is gross, my lord. That is gross. Net
It is gross.
54,000 gross. Out of that,
which page of their affidavit of asset?
Page 39 is the latest, May 2025.
No, you have given a
Salary certificate, yes.
Where is that?
Page 39 of their affidavit.
Page?
39. I'm my lord the constable in Sima Surakha Ball. And my lord posted Uttarakhand. And posted in
posted at Taki.
Uttar Pradesh. No.
And then page 39.
Page 39. My lord, my asset.
Affidavit of asset, yes.
Their affidavit of asset. my lord.
Obviously.
34 তো আগে দিল। আমি বলছি latest. 34 onwards, my lord, I have given my lord the.
Now let us see the deduction. House rent allowance we won't deduct.
Yes.
What is R2H2? 15. Column 15. What is this recovery? I fail to understand. Huh? Hair cutting allowance and soap toilet allowance also you have. Yes.
You also kindly see the page.
R2H2 we don't understand. What is R2H2?
I get to it. My lord, that is border allowance.
If he is posted in the border.
Yes.
But it's his income.
Yes. Absolutely.
So the right hand side is the deduction.
Right hand side is the deduction.
What is decoy mess cutting? And recovery of pay and allowance? What are these?
That is the canteen charge, my lord. Where, my lord, I used to take meal and.
And this recording of pay and allowance, what is this?
Pay and allowance. 7,301.
Deductions, you have to know what are the deductions. Otherwise, we'll take the entire gross.
Page 56. And once, my lord, due to the dispute of the matrimonial, my lord, matter, I was, my lord, without leave. I was absent without pay, and that is why.
What does the matrimonial?
That is, my lord, the trauma, that mental trauma I suffered, my lord.
Suffered such a way you are posted in the security forces. You have suffered mental trauma.
I once, my lord, thought, my lord, to leave the job. That is the whole difficulty, my lord. I'll tell you.
What is psychiatrically treated?
No. My lord, what happened? I will tell you that on the basis of the complaint made by my wife, my lord, 50% of my salary has been deducted. There is no, my lord, adjudication.
There cannot be that.
That is there.
Due to complaint of the wife.
Yes, that is there. And thereafter.
Why did you challenge it in a proper?
I did not get the scope, my lord. My criminal suit has been filed. No application for maintenance was there.
If there is an illegal deduction, you can challenge that in a court.
It is there. Thereafter, my lord, I agitated. Thereafter, 40% has been. It has reduced to, my lord, 40%.
GPF is voluntary or? GPF is voluntary.
Statutory, my lord. This is mandatory, my lord, 10%.
Acha. Yes. So 5162, yes. So 70,000 minus 5162 is around 65,000. Recovery, no, you did not attend. You have your pay has been.
The reason is that, my lord, that is I will submit, my lord, at the time of my turn, my lord. Your lordship kindly bear me for a moment. After, my lord, my learned friend finish.
Yes.
This is, my lord, before placing the application, my lord, two, three things are which are admitted, my lord.
What are admitted?
Marriage admitted, issue admitted.
You have a child?
My lord, I am for the wife.
You have a child?
Yes, my lord.
What is the age of the child?
9 years.
Daughter?
Son.
With you?
My lord.
With you. So what is the alimony you have claimed? Let us see
I
that.
claim, my lord, 25,000 and 25,000 for
litigation
cost. My lord.
So
he is a student of class 4 and he is also doing computers training and drawing classes and other extracurricular activities. And after the passing of the degree in the month of December 2024, I am not getting any maintenance.
you don't have any income according to
No. I have already annexed my bank statement since 2021 to 2025 in my affidavit in reply.
Your child is studying in a school?
My lord. Kindly come to my affidavit in assets, my lord.
Yes.
I have annexed the all relevant document. Kindly come to page 18, 60. Start from, my lord, page 14A, Annexure A.
Page?
14A.
Annexure A, yes.
Annexure. This is the, my lord,
school fees.
Anand Marga School. Thereafter, my lord,
This is the page
This
16.
is a higher secondary board, Madhyamik board.
That's I am not, my lord, aware. It is KG English medium school, my lord.
All right.
And that is my lord, month of January 25, thereafter February 25, my lord.
So about 2,000 per month.
Per month, my lord. And thereafter, my lord, kindly come to page 21. Here he is taking, my lord, computer classes
Yes.
and paying, my lord,
Page
500.
20 is his school fees.
And thereafter, my lord,
May 2025. Page 20 is not computer classes. For computer fees, yes, that has been added.
yes,
1,500 plus 500.
that is in his school. And he is getting private.
Private tuition, where do I find that?
Well, 21.
21.
21, my lord. That is Bhatpara Jatiya Juva Computer Center.
All right.
And then, my lord, page 22, my lord, Level Art Academy, where he is taking drawing classes, my lord.
What is the amount for that?
That is 1,000, my lord.
So 1,000 there, 500 here.
Yes.
500 here, 1,500.
Right.
So 3,500. 2,000 plus 1,000. 3,500 and his other expenses obviously are there. Food,
Occupation, my
dress.
lord, food, trades. I have claimed 9,000 in respect of that, my lord.
9,000 for the child.
Child, my lord. At page, my lord, my affidavit of asset, page 6, my lord.
9,000 for the child and then 16,000 for you.
16,000, my lord.
Total you have asked for 25,000.
25, total 20.
Has to be then 16,000.
But
yes.
and my lord, I am deciding. And my lord, I am residing in a separate rental house.
What is the rent per month?
Per month, 5,200. That document is there, my lord, in affidavit of reply, my lord. In my affidavit of reply,
5,000?
200, my lord.
So including that, including everything, you have asked for 16,000 per month.
25,000, my lord. Huh?
So
Yes.
9,000 son, rest 16,000, including everything, you have asked for, including son, 25,000. Yes, Mr. Bonik, it seems to be reasonable.
Your lordship, kindly see. Apart from this, my lord, the income which has been arbitrarily deducted till the disposal of the matrimonial suit. My lord, the wife is MA in Bengali, my lord, and she, my lord, continuing her classes, private tuition classes, as well as she's a good dance teacher, and she is earning. That is our contention, 15,000 per month. That a part, your lordship, I will dispute so far as the documents which has been annexed in the affidavit of asset and liability as well as in the reply. Your lordship, kindly have a look to the yes, the affidavit of asset and liability first. Page 16. Your lordship kindly sees that the admission fees and all these fees have been calculated. Now the bill has been issued on 5th of January, which is Sunday. I do not know, my lord, which school, my lord, issued this type of bill on Sunday. That apart, your lordship kindly sees the categorical bills which has been issued severally. Your lordship kindly sees the next month bill. This is the bill number 8501. Now next month bill issued 8503. I do not know how many people are there.
2 students.
Your roll number is 6. My son roll number is 6. If your
It can only be 2 students because the next one is 8505.
yes, 5. Thereafter,
Right.
8507, page 19.
Yes.
Thereafter, 8509, page 20. These all, not only this, when he is paying for computer and other expenses to the school. Now these private tuitions are also there. I am not disputing that may nowadays is required. Now your lordship kindly see the next dispute, affidavit in reply.
Yes.
Page 14 of the affidavit in reply. Paragraph 28, what she has stated.
Yes.
She is, my lord, stating all these things by swearing affidavit. The allegations, may I read, my lord? The allegations made in paragraph 32 of the said affidavit are not admitted to be correct in the manner as alleged or at all. It is stated that when the can number 225 was affirmed on 29th of April 2025, that is, my lord, the application for alimony. At that relevant point, the petitioner was with her parents, but subsequently in the month of May 2025, for betterment of the minor child and his education, your petitioner was compelled to reside in a separate tenanted house on rent close to the school of minor son. It is stated the distance of the school from the parent house was 30 kilometers. Hence, I started residing there as son school is nearby that. Your lordship, kindly come to the annexure. That is the
Tenancy agreement.
tenancy agreement. Page 46 first.
Yes.
Bablu Biswas was the tenant. If your lordship kindly, sorry, landlord.
Landlord is Bablu Biswas.
Yes, but no signature was there on behalf of the Bablu Biswas. Next page, page 47. The first paragraph, whereby the landlord agrees to let and the tenant agrees to take monthly tenancy, basis the house for his dwelling purpose described in the schedule below for the terms of 11 months commencing from 1st day of January 2025. Now she is stating she has started residing in the tenanted premises on and from May 2025 because of the distance. These all manufactured, my lord. If your lordship kindly, my lord, some
But
of
the
the
date of signature is 14th of May.
Yes, that is true.
No, it can be there. It can be
No case
giving
has
effect from date of.
No case has been made out as such. If your lordship
Yes,
kindly-
made out a case. He shifted and tenancy agreement was.
she stated that on 24th of April, she was with her parents. But
Yes.
subsequently, on and from 14th of May, since the school distance is much lesser.
14th of May, they signed that document and
That
it
is
may give effect, have been given effect to previous.
That is true, my lord. But there must be something. Effect has been given from
So
the
January, where do you get it? This agreement made on 14th of May.
No,
the
no, no.
first
Your
page.
lordship, page 47, first paragraph, whereby the landlord agrees.
That was the period you mentioned. Retrospectively, it may be. This agreement, the first page says the agreement is made on 14th of May.
14th of May. That is notarized.
Maybe that
notarized
was the
agreement.
condition.
Notarized. That case has not been made. That
Everything on 14th May.
I have taken the tenanted premises at this
May.
Place from May. That has not been stated, but it is.
It is executed itself on 14th of May.
It has been executed, my lord, but it has got effect from January 2025.
Maybe.
And that case has not been made out. That is my, my lord, submission before your lordship.
That does
because
not.
that at the time of affirming the application for maintenance, she has stated, I used to reside along with my son in the parents' house. Thereafter, due to distance, I take this rented accommodation. Now the rented accommodation is given effect from the, now she actually taken the burden of paying this rent from January when she has started residing in May. 5 months she paid the amount of 5,200. These are all.
Maybe the salami is adjusted like that.
Your lordship, kindly consider.
Salami is otherwise illegal.
This is
it's not unheard of.
Now these documents are everything has manufactured, my lord.
We cannot arrive at that conclusion. Notarized document.
The fact that up till, my lord,
and yes, you are right. The landlord name is different.
Yes. Probably her
wife
signed the, but no attorney. Huh? And Payal's house also there. I do not know who is she.
Maybe he's dictated by his wife, unlike you.
All are assumptions.
Unlike
we
you.
Cannot, this
manufacturing is also assumption. Manufacture is also assumption.
So something where from it can be presumed that
his wife is not like his wife, the landlord's wife. Maybe
that is true. That is why this has been manufactured. I respect to some.
May not be manufactured.
And apart from
but that voucher alternate number that will ask him.
Your lordship, kindly summon the school.
If there is any.
It's a primary school, my lord.
That's why maybe 2 students also. If it's government school, then maybe 2 students also.
And my lord, I wants to admit my son, my lord. I tried to get my lord hold of my wife several occasions after the disposal of my suit in my favor, but she did not pick up my phone. I do want to get my lord,
No,
give
no.
my lord maintenance to my son because that is my son.
It was your divorce suit that was decreed. So how can you get hold of her now?
No, I used to, my lord, I called her several occasions to pay something because child is mine. But she did not pick up the phone, my lord.
You did
Apart
not.
from the fact,
How
my
does she know why you're
she
calling?
initially applied for
You
the
obtain a divorce decree. Why should she pick up your phone?
No, because of the my lord, child. For providing my lord,
There is
maintenance
no
to the child.
application by you at any point of the child is all along with the mother.
All along
You
with
have,
the mother.
have you asked ever for making payment, shifting school,
I
seeking
actually-
custody,
I actually
visitation?
posted in several
Then-
places, my lord. That is true. That is what I cannot, my lord, go beyond the my lord fact. I cannot go.
Only that
beyond-
voucher point will ask Mr. Shah.
One thing, more thing, that the application initially filed when the divorce was pending for maintenance under 125 CRPC at that point of time. Now that has not been my lord, disposed of. That has been rather withdrawn since he did not take any initiative in that application. Now one complaint has been made.
That is
by-
pending. How can it be
That is I
withdrawn? How do you
I
say?
annexed the.
You say it has been disposed of as
disposed
withdrawn.
of, withdrawn.
Achha.
Now,
Maybe because of their alimony application before the civil court.
initially that is their real lordship. Thereafter, she made an application to the command officer. Now, on the basis of that letter, my command officer started deducting the 50% salary from my without any hearing.
Where have you
admitted.
stated that? Have you annexed that letter?
That is their case. That is admitted. That is admitted. That application in the application for alimony, she has specifically stated.
Show us that portion
Yes.
in the alimony application.
Ah.
That due to their letter, it was deducted.
My lord, kindly come to page 10, page 5, paragraph 10 of my case.
Yes.
And it is also reflected in my lord judgment itself, by which
We'll look
decree
into
was
that.
granted.
Yes, Mr. Bonik.
Yes, page paragraph 10.
Read it out.
But it is pertinent to mention herein that initially during the pendency of the matrimonial suit 434, your petition.
That is by way of alimony.
No.
That is the statement.
No application has been filed in the court below.
Your petition of pendency of your petition was allowed
So
50% of the
50% of salary of the respondent towards maintenance of duties at her minor son, white order dated as so passed by the command officer.
You should have
which
challenged
was-
that.
No,
Should have
that
challenged that.
initially they made an application
There,
before the
Lord, I
command
did
officer.
not- both cannot.
Lord, I did not challenge it. That is there. I cannot.
Then
go
it
beyond
will
that.
have accused
Now
to that.
thereafter, no. Why I am saying, Lord, all these things, Lord, this application has never been made. No, Lord, she did not, Lord, place any, Lord, requirement of her or child.
You have admittedly married somebody else.
Yes, that is there.
That is there.
Initially, your lordship was disposed of the CAN application, CAN 1.
On that finding.
Yes. Stay was.
Pay them alimony at least.
No, alimony I must, my lord, because my child is there. But your lordship kindly consider these are the false, my lord. On the basis of this false statement, your lordship do not make, my lord, courage this type of, my lord, documents which has been showed.
How do you say it is false?
Your
Where is
lordship
your
kindly sees the execution of the document which has been executed in the Sunday. A school is executing a receipt on Sunday, 5th of January.
must
And
have been
thereafter-
wrong date was put. Yesterday I signed a document, not an order of court, by mentioning
Kindly
it to be
observe that
23rd.
Your lordship.
That does not itself mean that the document is a manufactured one.
That may not show some suspicious doubt. Suspicion is there. This is the court of justice. Your lordship kindly consider these things. That cannot be, Lord.
What else?
But I want to, Lord, admit my child to Central Kendriya Vidyalaya. But since I am in armed force, Lord, I do get every, and that is good school, Lord. Your
You
lordship.
did not remember the child throughout the pendency of your divorce suit. Did you ever file any application? She has been put into school by her mother. He's now 9 years old.
8 years old.
9 she has stated.
9 or 8, my lord.
Now
He was
8,
born
9
in
years old
2016.
must have been put in school at least at around 5 years of age, at least.
The intention was
So for
there.
4 years, where was the intention?
Intention was there, my lord. I will not approach the.
File a proper application. We'll think about that. That's a very good suggestion. Yes, what about the alternative number vouchers?
That is there, my lord, but I can't develop it, my lord, because
There are only
this
two
is the
students in the school.
student fees receipt, my lord. It may be issued by the school, my lord. I have nothing to do with this.
You are relying on this document.
Kindly see Anand Margo Primary School, KG English Medium. Whatever. And it may be, it might be, my lord, this may be issued by the school itself. একটা ভুল যখন ধরা পড়েছে
Alternate number vouchers for every month.
that is appear from the record, my lord. I have not suppressed anything. What I have received, I have announced.
This is a government school.
No, my lord.
Government school could not be Anandamargo school.
No. My lord, it may be they have issued one receipt to another student. Thereafter, my name has come.
Every month.
Maybe.
There are 2 students in total.
I have seen, my
Is
lord.
your client present or any instructing person present?
No, she has not come, my lord.
No, not her. Any other one?
But it is not a disputed, my lord. He is in his school. He is in Anand Bargo school. It is not disputed, my lord. And they have what they have stated that his father want to admit the student in Kendriya Vidyalaya. I have stated the aim of the student is very high, my lord. My lord.
What is very high?
The aim of the student, minor son, is very high. He wanted to be a doctor, and it has. I have been informed. I am submitting on instruction.
Yes.
He has talked to his father that I want to be a doctor. I want to be admitted in Narayana High School, which is very close to the Murshidabad where they are residing. And
that has to be within the means of the father.
that is true, my lord.
So
That is
Kendriya Vidyalayas are good. They impart standard education.
But my lord, during this session, in midway, they can't take admission, my lord. At present, the student is.
Should we give them? We'll dispose of the alimony application right now.
My
Decide it, and should we give them liberty to try for admission of the son?
No problem, my lord. No problem. That is burden upon father.
Mr. Bonik will dispose of the application, alimony application right now, and record your submission and his submission. And regarding Kendriya Vidyalaya admission, you can, take
For the
instruction.
betterment of the student, my lord, I am.
Fair enough. You are at liberty to take, steps in that regard. And if you can, if it's possible, file a short application with a copy to them. We'll allow that application and direct the son to be put there. No
Because
difficulty.
now in the middle of session, I don't think that he will get admission in another school, my lord. But when the session will start.
No, let them. So whenever the session starts,
Yes,
let them.
yes, my lord. No problem.
If he wants to get his son admitted in a better school,
Yes, fair enough, my lord. He
fair
is
enough.
entitled to my.
এটা নিয়ে কি করি? এটা তো এত ডিটেইলস আমরা যেতে পারি না। আর আনন্দমার্গ স্কুল কি করছে? তাহলে ওই 25 চেয়েছে তো ওর যদি আমরা 65 ধরি 5000 বাদ দিয়ে তাহলে অ্যাবাউট 65,000 পার মান্থ আসছে। 25
Lordship, at the time of considering, my lord, the quantum, your lordship kindly consider that I have another, my lord, set of
family to look after.
Apart from my old mother, who is suffering from ailment.
Every matrimonial should husbands have old
I
mothers.
am not my duty to, my lord, submit before.
They're revived even if they are no longer there. No, but that cannot be a factor. Yes, we cannot penalize you for marrying again. You have obtained a divorce decree, but
That apart, my one grandchild, maternal aunt was there, who is also dependent, 75 years old.
when she'll file an application for maintenance,
I
we'll consider.
stated in my, my lord,
Let the maternal aunt file an application for alimony.
I pay. I actually pay her. That is, my lord, I have stated.
Stop paying her. What can be done? You have to pay your wife. The alimony application has been filed by the appellant wife seeking lump sum, seeking total alimony of rupees 25,000 per month, compositely for herself and the expenses of her minor son of about 9 years. Full stop. Learned counsel for the petitioner stroke wife argues by placing reliance on the documents annexed to the affidavit of assets of the wife as well as the affidavit as well as the alimony application and the affidavit in reply, comma, that the monthly tuition expenses of the son is about rupees 2000, full stop. The cumulative tuition expenses, comma, taking into account the extracurricular activities and further computer lessons being imparted privately to the son, comma, take the monthly expenses of the son in that regard to more than rupees 5000. Full stop. Next para, insofar as the accommodation is concerned, comma, the petitioner wife claims that due to the distance between her parental home and the school of the son, comma, the petitioner was compelled to seek a closer accommodation and has shifted to a rental accommodation from May 14, 2025, for which monthly rent of rupees 5200 has to be paid. Full stop. Next para. In support of her contention, comma, the petitioner wife relies on a purported tenancy agreement annexed to her pleadings. Full stop. Next para. Learned counsel appearing for the respondent husband submits that the documents in support of the alimony application are manufactured, full stop, by placing reliance on the receipts of payment of school fees annexed to the affidavit of assets of the wife, comma, learned counsel for the respondent points out that the number of the said receipts for each consecutive month is alternate numbers. So for example, comma, the receipt for the month of February 2025 is numbered 8503, comma, that of March 2025 8505, comma, the receipt of April 2025 8507, and so on and so forth. Full stop. That itself, comma, it is argued, comma, shows that those are manufactured. Full stop. Next para also, comma, it is pointed out that although the wife has sought to make out a case that she has shifted to the rental accommodation on May 14, 2025, comma, the tenancy created by the purported agreement is for 11 months from January 1, 2025. Full stop. Thus, comma, it is evident that if the petitioner wife had actually moved accommodation in the month of May 2025, comma, particularly in view of her penury, PENURY, comma, she would not have paid rent retrospectively from January 2025. Full stop. Also, comma, the tenancy agreement is not filed by the landlord named therein. Full stop. Next para. Learned counsel for the respondent husband next contends that the respondent husband has admittedly remarried and has to maintain the said establishment. Full stop. He also has an aged and ailing mother and aunt, comma, for whom he has to bear the expenses every month. Full stop. Next para. Moreover, comma, it is submitted that due to the application of the appellant wife, comma, huge amounts of salary were deducted from the husband by the husband's employer. Full stop. It is submitted that the said factors should be considered while granting alimony. Full stop. Next para. Upon a perusal of the salary slip produced for the month of May 2025 by the husband, comma, we find that the total deductions reflected therein do not merit much consideration. Full stop. Insofar as the MESS expenses are concerned, comma, we are of the opinion that the same being necessary expenses of a person, comma, do not constitute a statutory deduction as such. Full stop. The amount of rupees 7301 for the said month, comma, which has been sought to be portrayed as compulsory deduction from the salary of the husband due to the complaint of the wife, comma, also does not inspire confidence in us. Full stop. Next para. The same, comma, even if so deducted, comma, has not been established to be directly connected to the complaint of the wife, comma, nor can it be said to be a statutory deduction. Full stop. In any event, comma, if the husband is of the opinion that unlawful deduction in that regard was being made from his salary, comma, it was always open to the respondent husband to challenge such deduction before an appropriate forum. Full stop. Having not done so and acquiesced to such deduction, comma, the husband cannot come before this court and while defending the wife's application for alimony, comma, set up as a defense such deduction. Full stop. Next para. However, comma, insofar as the gross provident fund deduction is general provident fund deduction is concerned, comma, to the tune of 10%, comma, we find that the same is a valid statutory deduction to the tune of about rupees 5162 per month. Full stop. The gross pay of the husband for the month of May 2025 is rupees 70,196. Full stop. Upon arriving at a sum by approximately deducting the GPF of rupees 5162 from such amount, comma, we find that the net salary of the husband comes to around rupees 65,000 per month. Full stop. Next para. As per the wife's pleadings, comma, the total amount claimed by the wife for herself, comma, including the rental charges as well as other expenses for herself, comma, the quantum so claimed is rupees 16,000 per month. Full stop. The amount claimed for the son is rupees 9,000 per month, including his education and other expenses. Full stop. Next para. With or without the rental costs, comma, we find from the materials on record that the monthly alimony of rupees 16,000 claimed by the wife for herself is not exorbitant by any means, comma, particularly keeping in view the employment of the husband in, you are employed in, you said, border
SSB, Seema Suraksha Bal.
Employment with the Seema Suraksha Bal.
Seema Suraksha. Sashastro Seema Suraksha.
Sashastro Seema Suraksha Bal. SS Suraksha Bal.
60th BN SSB.
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 Seema Suraksha Bal. Full stop. Next para. Insofar as the allegations that the documents produced by the wife are manufactured, comma, in the absence of any particulars of pleading regarding the same, comma, we are unable to form an opinion on a perusal of the documents annex that the said documents are manufactured ex facie. Full stop. Next para. Such an allegation has to be proved to the hilt, comma, which has not been done by the husband. Full stop. Next para. The tenancy agreement produced by the wife was executed on May 14, 2025 and signed on the same date by the appellant as well as one Aparna Bishwas. Full stop. Although it is shown in the tenancy agreement that one Bablu Bishwas is the landlord, comma, we are of the opinion that the said minor discrepancy does not invalidate the document itself, comma, particularly since it is a notarized document. Full stop. Next para. Aparna Bishwas. Who is Aparna Bishwas?
Most probably wife of Bablu Biswas, my lord.
You also say most probably.
I-
Next para. In any event, comma, as discussed earlier, comma, even without taking into account the rental expenses of rupees 5,200 per month, comma, we have already held that rupees 16,000 per month is a valid claim of the wife for herself. For sub next para. As far as the son is concerned, comma, although the wife has claimed an amount of rupees 9,000, comma, and taking into account that there might be certain minor discrepancies in the education, in the receipts of the monthly fees issued by the school, comma, we do not hold that such documents ex facie invalidate the claim for the son. However, comma, taking into account the expenses of the husband for his current family, comma, upon his remarriage, as well as that a rough estimate of 1/3 of the monthly income of the husband comes to around rupees 22,000, comma, we grant a total 22,000. We grant a total alimony of rupees 22,000 the petitioner wife, comma, for herself and a son. Full stop. Next para. As far as litigation cost is concerned, comma, an amount of rupees 25,000 is justified. Full stop. However, comma, we however, comma, the same can be paid by 5 equal monthly installments. Full stop. Next para. Accordingly, Can 2 of 2025 is disposed of by directing the respondent husband to pay alimony pendently to the appellant wife at the rate of rupees 22,000 per month within bracket composite amount for the wife as well as for the minor son of the parties, bracket closed. Full stop. The first such monthly payment of current alimony shall be made by the 15th day of July 2025 for the self-same month, and thereafter by the 15th day of each succeeding month for each such current month. For the next para, the arrear alimony from May 2025, comma, when the alimony application was filed, till June 2020, for May 2025, comma, when the alimony application was filed, and June 2025 shall be paid by July 31, 2025. Full stop. Next para. Litigation costs at the rate of a lump sum litigation cost of rupees 25,000 shall be paid by 5 monthly equal installments. The first of which shall be paid by July 15, 2025, and thereafter the next installments by the 15th day of each successive month till the total amount of rupees 25,000 is exhausted. Full stop. Next para. All the above payments shall be made by the respondent husband to the petitioner wife directly to her bank account, comma, the particulars of which shall be furnished in writing by the learned advocate for the appellant wife to the learned advocate on record for the respondent husband by tomorrow. Can you do it, Mr. Shah?
Yes.
By tomorrow.
Your Lordship, kindly consider one thing, that there is a loan, my lord. My client has taken 11 lakhs and he is paying 20,000 per month. So you will not
Oh,
be
already
able to,
decided,
my lord,
Mr.
pay the
After-
others.
after
Your Lordship,
adjudication,
kindly
we-
consider this aspect also.
After adjudication, Mr.
That is
No further
his
arguments.
investment.
We already decided. After we pass our order, no. Stay was disposed of. Stay application.
Yes, nothing pending, my lord.
You now file your paper books and all.
My-
In view of the appearance of the respondent through his learned advocate, no respondent through his learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a fortnight from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. First up, it is made clear that the office report regarding non-deposit of Talabana and postal costs, comma, dated June 20, 2025, is deemed to stand waived in view of the appearance of the respondent. বললাম যে হ্যাঁ ক্যান্টু ডিসপোজ বলেছি কি বলছো ক্যান্টু ইজ ডিসপোজড অফ বাই
Much.
থ্যাংক ইউ Mr. Bonik, please give your appearances. Yes. Yes. Who is appearing in this matter?
I appear for the plaintiff appellant. Your Lordship had directed me to, my lord, communicate the order, file the affidavit of service, and affidavits in the meantime was directed. My learned friend has filed the affidavit, but belatedly, my lord. May I humbly pray
He has not yet filed. Yes, he is filing. You are ready with the reply.
My lord, reply, your lordship, I was praying for 2 weeks, my lord. It was
What is this affidavit of service?
service.
The affidavit of service filed by the petitioners and the affidavit in opposition filed by the respondent. Respondent number one.
My lord.
One today be kept on record. We are dispensed with service on pro forma. Be kept on record, full stop. On the prayer of the appellants, comma, the time for filing affidavit in reply is extended for a fortnight from date. Full stop, the delay in filing the affidavit in opposition is condoned. Full stop, next para, the application shall next be listed for hearing on July 9, 2025.
Deeply obliged.
Please, my lords, my lord. The affidavit of service, my lord. Lord,
They have received?
Yes,
All?
Lord,
You are appealing for all?
2 to 6.
What about one you have served?
My lord, only problem is, my lord, we have tried to serve the respondent number 1. I believe he's not, because I believe it says insufficient address for some reason, lordship.
But did they appear in the trial court at the same address?
Yes, we've given that address only, lordship. And he's not on caveat, lordship.
The affidavit of service filed today be kept on record, full stop. The respondent numbers 2 to 6 are represented by counsel, full stop. Insofar as the respondent number 1 is concerned, comma, although the track report indicates that the address given in the postal article in respect of respondent number 1 is insufficient, comma, the address at which the same was sent was the same as that which was furnished in the trial court. Full stop, since the respondent number 1 contested from the same address in the trial court, comma, we deem that the respondent number 1 is deliberately avoiding service and accordingly treat the application to have been duly served. Yes. What is the matter about?
Well, we've come up in appeal against.
Are you enjoying any interim order?
Lordship, we were enjoying an interim order till the Order 7 Rule 11 application was allowed, and we are in appeal against that. Lordship, not before this honorable court. Lordship, before the trial court, we moved the plaint with the application. We got an interim order. The respondent number 1 filed an application under Order 7 Rule 11, which has been
was for what?
Well, this is for declaration of my rights as a tenant. Well, this is a Waqf property, but this is not a Waqf matter. It does not fall within one of the disputes.
Their Order 7 Rule 11 premise was that Waqf property therefore should go to the tribunal.
My lord, that was one of the points raised, but then the trial court has found in my favor on that issue. But the issue is different, lordship. What has happened is, this property was originally given in tenancy to one Mr. Cook. In 2007, Mr. Cook surrendered the tenancy and it was given to another lady, Neelam Ahmed. Neelam Ahmed's tenancy was accepted by the Mutawali. There's an affidavit to that effect. In 2008, I came in as tenant in place of Neelam Ahmed, and there is an affidavit given by the Mutawali recognizing me as a tenant. Subsequently, I have been paying rent regularly. I have all the rent receipts. They are all annexed. What happens, lordship, is in 2009, long after Mr. Cook has anything to do with the property, an ejectment suit is filed against Mr. Cook. And
by them?
Yes, lordship.
They are the Mutawali?
The Mutawali is R1, lordship.
Achha, very well. Then?
My lord, in the ejectment suit, there is a decree. When I come to know of it, I file an application under Order 21, Rule 101. The trial court considers my application and comes to a finding that this application is beyond the scope and jurisdiction of the trial court. That is the order. Now, my lord, after that order is passed, they're all annexed, lordship. I will place them one by one. Now, once my application is rejected on the ground of jurisdiction, I now seek to assert my right independently and I file a suit. I get an interim order. Now, my lord, when the Order 7 Rule 11 application is filed, one of the grounds taken is because your order 21 rule 101 had been dismissed, you it's res judicata, you cannot file a suit. That is the ground on which the order 7 rule 11 has been allowed.
You're challenging that.
And I'm in appeal, Lordship, from that order, Lordship.
Show us the order 21 rule 101 dismissal.
Lordship. Lordship will kindly come to page 223.
That is the crux of the matter.
That is the crux of the matter. And Lordship, also the fact that that ejectment suit was instituted in respect of a person who's a complete stranger to the property, admittedly by then, because I can show it from the respondent number one's own documents that more than 2 years prior thereto, that concerned gentleman had nothing to do with the property.
What we fail to understand is why was it held to be beyond the scope of order 21.
Lordship kindly comes to page 223.
Yes. That was during pendency of the execution case.
Lordship.
So the execution case is still pending.
It is still pending. It's still pending.
Let us see. Yes, grounds.
Lordship will see page 223, Annexure O, Volume 1.
Here. You did not challenge this.
Instead of challenging this, my client chose to file a suit.
Great. Let us see the present
Lordship will kindly come to page 31, 36. Lordship.
Look at the
page 36.
memorandum directly. Just refer to the internal pages.
Lordship.
Waqf Act was also one of the grounds.
But that was the finding in our favor, because there's a Supreme Court judgment which was relied on, which lists the nature of disputes which falls within the jurisdiction of the Waqf Tribunal.
They must have relied on Anis Fatima.
Lordship.
And you relied on the subsequent judgment. I forgot the name of
Lordship. That's been recorded in the
Yes, 2013. All right, very well. So, now let me deal with the second question. Let us start from there. Second last page.
Lordship.
Before that, Waqf.
Lordship.
Yes, if other cases. You are not claiming through Cook.
Lordship, we are claiming through one who had given affidavits in our favor recognized.
No, you say that Cook's tenancy, Cook gave it to Nagma Ahmed.
Neelam Ahmed, Lordship.
Neelam Ahmed, Cook gave it to Neelam or landlord directly?
Cook gave it to Neelam by seeking the permission of the landlord, and the landlord executed an affidavit.
Tenancy by Cook.
Lordship.
Given by Cook.
But then, Lordship.
According to you.
According to us, Lordship, Neelam replaces Cook. Lordship, may I show page 65 of the brief, Lordship? Lordship will kindly see how I get my rights from. Because this is a case of surrender of tenancy.
You will be showing us from your plaint.
Lordship, this is a part of my application, Lordship. I've annexed these with my stay application.
No, we want to look at your plaint. What is your plaint pleading? It will be decided by that.
Lordship, as
page 43.
Lordship will kindly see my prayers are at.
Not your prayers. What is your claim?
Claim.
CV Cook regarding CV. Let us start from Cook. How do you derive title? Where is your chain of title?
Lordship.
Yes, para 17. Upon surrender by Neelam.
Lordship.
Oh, yes. Surrender by Neelam, who had obtained upon surrender by civic.
Lordship.
So independent tenancies from the landlord according to you.
Grateful Lordship. And that's been allowed, rents paid, bills, receipts issued.
Directly by the landlord.
Lordship. And I will show the affidavits. They're all annexed.
Yes.
I annexed it with my plaint also.
Let us just complete that. Civic. We are just returning to the second last page of the impugned judgment.
Lordship.
Oh, the court dismissed on the ground of Order 20 Rule 101 being available to you.
Lordship. But then I filed the suit because my Order 21-101 was dismissed on the ground of it being beyond jurisdiction. Now, Lordship, that could have been challenged. Lordship, good, bad, indifferent. I filed because it was held to be beyond jurisdiction. I accepted it. I asserted my rights.
That order does not confer jurisdiction on the suit court to take up the matter. If that was a wrong order, you had the limity of challenging it.
Lordship, but at the same time, I'll humbly submit, Lordship, in respect of my rights in.
If you pass a wrong order, that cannot confer a right on you.
Lordship, I bow
and it's
down
a statutory bar.
Lordship. What?
Not a bar. We have to consider that 2101 is a bar, complete bar. Yes, it will be a bar. Yes, the execution case was pending and you were a third party.
Complaining about disposition.
Why shouldn't it be constituted as a bar?
Lord, may I place Order 21 Rule 101?
2100 rule. CPC. ওনাকে
CPC আছে?
ওই তো।
Please give it. আচ্ছা
তুমি ওটা একদিকে রাখো এত মানে কমপ্লিকেটেড হয়ে গেছে না ম্যাটারটা
হ্যাঁ
Yes, 101. Read the language.
Lordship.
Mr. Shortcut.
Question to be determined.
And not by a separate suit.
All questions, including questions relating to right, title, or interest in the property arising between the parties to a proceeding on an application under Rule 97 or Rule 99 or their representatives and relevant to the adjudication of the application shall be determined by the court dealing with the application and not by a separate suit. And for this purpose, the court shall, notwithstanding anything to the contrary contained in any law for the time being in force, be deemed to have jurisdiction to decide such questions. Lordship, I bow down now. And that
not by a separate suit.
Not by a separate suit. Lordship, we filed the application. Now, Lordship, may I place...
You only file your appeal against the misappeal against... what was the valuation of the suit? No, that goes before the district court probably.
Lordship.
With the section 14 and a 5. If we were there, if it was before us, we'd advise you to file it immediately. So.
Lordship.
But we cannot do that because, yes, what were you citing? Yes.
Nothing, Lordship. I want to show some further documents from the scope of my application and the plaint, if Lordship is convinced as to whether
that it's wider than this.
If I may try and convince.
The language of 101 is very wide.
It's very wide.
It's connected. If it's connected to that suit, decretal property, then you are gone.
That is correct, Lordship.
This is a peculiar order, and
it is
the prayer sorted by the plaintiff. There, that is the language of the. Should have challenged on that sorted ground only. You have been slaughtered by the sorted.
Lordship, unfortunately, we are not part of the.
No, but
I definitely would have advised.
This is of 2022.
Lordship.
Go and file whatever you have to do. We'll dismiss your appeal.
Will my lord give me 1 second, Lordship? May I take this instruction as to whether I should?
No, have it dismissed by us instead of withdrawal. You pay us now. Now we'll charge.
Lordship kindly gives me a one.
Take instruction. Let us. withdraw করলে আচ্ছা ডিসমিস করলে ভালো লাগবে এখনো পর্যন্ত ভুল ধারণাটা পারসিস্ট করছিল ওটা যা ঠিক করে
My lord, I'll try and show whether the scope of the suit can be enlarged or not?
Show
If
right now.
Lordship.
What can be larger than all questions? What
to
can
be-
be larger than all?
Malad, I'll be very honest, Lordship. I will not.
All, it cannot be wider than all.
Can't be wider than all.
What is
Lordship.
all? That is where we are.
It's
If it is regarding that suit, obviously, if it's an eviction suit, if you seek a matrimonial degree between the same parties, it would not be covered by all. But all questions determining regarding that the title to that property is what is the brainwave.
My lord, in that case, may I, because I will not argue beyond what Lordship
And
has
we will
pointed
not
out. There's
hold anything
nothing.
beyond the law.
Lordship. So there is, I will not mislead the court, Lordship. In
It
that
will be
case,
best
Lordship,
for you if you dismiss the appeal and the application itself.
Lordship. My only
Why
prayer
are you nodding your head regarding the liberty which you are going to give?
Lordship, because what is liberty? The only reason, Lordship, we decided to take this chance before your Lordships is only on facts.
You thought we don't know the law. That could be the only reason, Mr. Sharma.
I can never match up. I can never match up to my lords.
No, there could be no other reason.
No, I can never match up to my
All
lords.
101, even apparently only this learned person did not know.
Lordship.
Otherwise, everybody knows. Every law student will know. If they have studied CBC.
Lordship, I bow down to my lord. My lord, the only thing was on facts. If my lord may consider one small fact, which is, after all, they're running a charitable institution, underprivileged children.
That we have seen. That is the first thing we saw. That's why we are.
We only wanted some protection, Lordship. If Lordship grants us, some liberty in the meantime, that Lordship permits us to move the appropriate forum, challenge that order with.
Mr. Bhattacharya will not grant any liberty in words, but will make some observations. This will be utter injustice.
Observation, my lord, because that observation, they have to get it from the appellate court.
No, this is the appellate court.
No. From
appellate court, they'll not get the observation. They'll get the relief in the appellate court. Observations, they'll get.
Observation, my lord, not to extent that the relief is smoothly gone by the appellate court, my lord.
No.
Not to some extent.
My lord, because the ground for dismissal of orders, allowing orders.
This will be utter injustice due to act of court.
It's not that way. They were not
sit tight. They filed a suit.
To file a suit, they had to approach the appropriate forum.
This is an order of a competent court, civil court.
Court may be wrong, court may be right.
Yes.
Therefore, there is a forum to challenge that. Court has the right to pass.
They did not challenge that. They accused and they filed a suit.
That would be covered by section 14.
Yes. That is the observation we are discussing about. Anyway.
They were aware of it.
In view of the very short point involved, we take up the appeal along with the application for hearing together. Full stop. The present appeal has been preferred against a deemed decree whereby the plaint of the appellant's suit for declaration and consequential reliefs has been rejected under Order 7, Rule 11 of the Code of Civil Procedure on the ground of the bar under Rule 101 of Order 21 of the Code of Civil Procedure. Next para, in brief, the appellant, the respondent had filed an eviction suit against one Mr. Cook, who purportedly was a tenant in respect of the suit property. Full stop. Subsequently, an ex parte decree was obtained in the said suit, which was put into execution. Full stop. The present petitioner, the present appellant, a stranger to the said suit, filed an application claiming its independent rights under Order 21, Rules 97 to 101 of the Code of Civil Procedure. Full stop. The said miscellaneous case, the said application was registered as miscellaneous case number 48 of 2018. Full stop. In the said miscellaneous case, the appellant pleaded that the tenancy of Mr. Cook was subsequently terminated and a fresh tenancy was created in favor of one Ms. Neelam Ahmed. Neelam Ahmed. Full stop. Thereafter, comma, according to the case of the appellant, comma, the tenancy of Neelam Ahmed was also surrendered in favor of the respondents and a fresh tenancy was created in favor of the appellant. Full stop. Next para, however, comma, video order number 34 dated April 21, 2022, comma, the executing court dismissed miscellaneous case number 48 of 2018 on the peculiar ground that, on the cryptic ground that since the prayer as sought by the appellant was outside the purview of the jurisdiction of the said court, comma, the miscellaneous case could not be entertained. Full stop. Next para. The present appellant, comma, however, comma, instead of challenging the said palpably erroneous order, comma, instituted a fresh suit, comma, acquiescing to the within double inverted advice, double inverted, given in the said order. Full stop. Next para. The said suit is the present suit which ultimately culminated in rejection of its plaint under Order 7, Rule 11, on, comma, ironically on the ground that it was barred under Order 21, Rule 101 of the Code of Civil Procedure. Full stop. Next para. The other ground taken in the Order 7, Rule 11 application as to the suit being barred by the Waqf Act was not entertained in the impugned deemed decree. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we completely empathize with the plight of the appellant, comma, who was caught between the devil and the deep sea, comma, comma, it being observed by the executing court that an application under Order 21, Rule 101 of the code was not maintainable, while the other court, comma, that is the present trial court, comma, dismissed, rejected its plaint on the diametrically contrary view. Full stop. Next para. It has been argued by the respondent that the appellant cannot take advantage of the erroneous order of the executing court and ought to have preferred an appeal against the same. Full stop. We completely agree with such proposition, but yet, comma, we find an ingredient of bona fide doubt in the mind of the appellant in whether to prefer an appeal against the order of the executing court rejecting its earlier application under Order 21, Rule 101 of the Code of Civil Procedure, or to institute a fresh suit in that regard. Full stop. Since there was an order of a competent civil court within bracket the executing court bracket closed, comma, erroneous or otherwise, comma, staring at the face of the appellant, comma, we cannot put much blame on the appellant on mistakenly preferring a suit instead of an appeal against the said order. Full stop. Next para. However, comma, despite such ingredient of bona fides, comma, we are unable to accept the contention of the appellant that the present suit is maintainable, comma, since it is undoubtedly barred by Rule 101 of Order 21 of the Code. Full stop. The language para. The language of Rule 101 is unambiguous. Full stop. It provides that all questions, alta italics, questions within bracket including questions relating to right, title, or interest in the property bracket closed arising between the parties to a proceeding on an application under Rule 97 or Rule 99 within bracket of Order 21 bracket closed, or their representatives, comma, and relevant to the adjudication of the application, comma, shall be determined by the court dealing with the application, and not by a separate suit, italics shesh. Full stop. Full stop. Next para. Hence, comma, FAT 246 of 2025 is dismissed on contest, comma, thereby affirming the impugned judgment and deemed decree dated May 8, 2025, passed by the learned fifth bench, passed by the learned judge, fifth bench, City Civil Court at Calcutta. This is City Civil Court.
Yes.
City Civil Court at Calcutta in title suit number 1575 of 2024. Full stop, next para. However, nothing in this, consequentially, can 1 of 2025 is also dismissed. Full stop, there will be no orders to cost. Full stop, next para. It is made clear that nothing in this order shall preclude the appellant from preferring an properly constituted challenge against order number 39 dated April 21, 2022, passed in miscellaneous case number 48 of 2018, subject to the provisions of the Limitation Act, including section 14 thereof.
Only one thing, my lord. Two words have gone on the record, my lord. My lords have held that
Palpably illegal.
My lord,
Unless we say that this order is justified.
no, because
Either both orders cannot be correct. If we dismiss the appeal, that order has to be palpably wrong.
no, my lord, that should not give up, my lord, handle to the learned
No,
appellate.
Mr. Bhattacharya, see, if that order is not palpably wrong, then this appeal should be allowed. If that order is not wrong, saying that a suit is maintainable and order 20-101 is not maintainable, if that order is not wrong, then they win this appeal. Then a suit is maintainable. We have to say that. You cannot get a bypass or a walkover.
Very well, then, my lordship's observation will not influence the mind of the my lord appellate court.
It has to influence the mind. We have put it in our order to influence the mind. Not in this case.
Grateful lordships.
They cannot suffer both ways.
Grateful lordship.
Thank you. Put in, let us see.
Lordship, it has been paid.
It
has been paid, lordship.
চালানটা দেখিয়ে দাও না তাহলে।
হ্যাঁ। তোমাকে চাইছো আমি বুঝি তো?
1100 deficit court fee.
Lordship, I believe it's been paid, lordship.
আচ্ছা, একটা লাইন অ্যাড করে আচ্ছা, এটা ডিগ্রি ফর্মই তো হবে। অ্যাপিলটাই তো ডিসপোজাল করে দিলাম। ডিগ্রি ফর্মেই হবে।
order 7 rule 11
সাবজেক্ট টু করে দিই।
deemed to be a degree.
ও, সার্টিফাইড কপি দরকার নেই।
June, lordship, it's been paid, lordship.
প্রথম লাইন একটা ছিল। Counsel for the appellant that the deficit court fees, how much has been paid?
1100, my lordship.
That deficit court fees of 1100 has been paid on May 20.
On June 20.
June 20, 2025. Anything else, entry number or something not reflected there?
Lordship, it's reflected on the website status, lordship, that
which is also reflected in the official website of this court. So accordingly, the defect in that regard stands cured.
They have stopped giving us. This is the problem we are facing. A dash, those A numbers were
That has stopped.
Now it's all uploaded in website.
Uploaded, yes. At the time of deposit, they don't give you anything. You pay by
Chalan.
Chalan, there is a number.
But
grateful, my lord.
Thanks.
Great.
Next.
No, sir, I am applicant of the appellant.
Yes, Mr. Das.
Last occasion, your lordship asked us on the affidavit of opposition against the can 2, that is a stay application.
You have to file the opposition.
Yes,
Yes. What about that?
I have served the copy
Regarding occupational charges.
of occupation.
This is the reply.
File the reply. Just now sorry to.
You're giving a copy now.
Just
Come back tomorrow. Go through that. Tomorrow, day after, whenever.
Wednesday, tomorrow another matter.
Affidavits in opposition and reply filed today be kept on record. Full stop. Since a copy of the reply is only served here and now on the learned advocate for the respondents, comma, to enable learned counsel for the respondents to prepare themselves in the matter, let the same stand adjourned till June 25, 2025. Day after tomorrow. There is a ticket. Yes.
Well, item number 38, my lord, I appear on behalf of the defendant, appellant, my lord.
I am appealing for
May I
the
start?
respondent plaintiff.
May I start, my lord?
It will take long.
No,
Seven-
this is
7 minutes are left. We can probably.
My lord,
The appeal can be decided.
yes, yes, my lord, because your lordship was pleased to direct me to serve a copy of this application about this party, my lord, I challenged the order. A status quo order has been passed, which is bereft of any reason. My lord, a suit for declaration of title, partition, and constitutional pair of injunction, my lord. The plaintiff has filed a suit that this LR plot number 2135 belonged to his predecessor's interest, my lord, and the 21 decimals of land was transferred. 4 decimals has been transferred in favor of the plaintiff, and 17 decimals remained with the plaintiff. And I, being a co-sharer, trying to disturb his position, he files a suit for partition, declaration, and constitutional injunction. On that score, my lord, I filed a written statement claiming that the 24 decimals, my lord, 17 decimals has been acquired by the state of West Bengal. It was in the pleading itself, my lord, and in the written objection, my lord, I have categorically stated in paragraph 4 that 17 decimals land belong to the state of West Bengal.
What was the total property, suit property?
21.
Out of 21, 17 has been acquired.
17 acquired.
According to you?
According to my case, my lord, and 4 decimals has been left. Therefore, he cannot be a co-sharer. My lord, the learned trial.
Regarding that 4 decimal, he will be a co-sharer.
Demarcated portion 4. 17.
Demarcated 4.
Yes. 17 acquired by the state of West Bengal by for erection of.
No, you are joint owners of the entire 21. That much you admit.
No, I'm the absolute owner. I'm the absolute owner of 4 decimals of land. If your lordship kindly comes to my plaint, I shall show the plaint itself, my lord. And the learned trial judge, what has happened, my lord, the court has quoted the case, but
Not decided, not adjudicated.
Not adjudicated, my lord. That court, my lord, the status quo order was filed without
The issue raised by the defendant not liable to be determined. So,
convenience and court passed an order of status quo. And your lordship,
reasoning.
no reasoning, nothing, my lord. Therefore, this type of orders cannot be moment scrutiny. My lord, I've got a division bench judgment. I can show before.
No, that 4 decimal was a demarcated 4 decimal.
Demarcated 4 decimal. My lord, therefore.
Yes, what do you say? There is no reason in the order.
In regard to my lord, so far as the acquisition is concerned, I have the information which I have collected. It has never.
No, but this had to be, that had to be considered by the trial court. You are enjoying an.
It has been considered.
No,
where?
Yes,
please, 1 minute. You are enjoying an ad interim order.
Yes,
This was the final disposal of the.
Final status quo.
Mr. Ghosh, we will, that since he was already enjoying, if this was not disposed of, that would be there. Ad interim order will maintain, but will direct the injunction to be reheard within a limit.
It's a temporary injunction disposed of.
Ad interim, during pendency of the temporary injunction, he was enjoying ad interim injunction.
Yes, that was.
Will restore that ad interim injunction and direct the injunction application to be decided afresh upon giving reasons.
Reasons has been there, madam.
Come to the second last page.
47. I am on 47.
This last page of the order,
that is-
having considered the materials on records and the documents filed in the case record, full stop. The issue raised by the defendants is not liable to be determined at this early stage of the suit. To determine the same evidence is required. Prima facie, it appears that the suit land are in possession of the plaintiff as well as the defendants having right title. How come? If a portion has been acquired, they have produced documents.
Acquisition is absolutely. I have the
That has,
documents.
reasons have to be adverted. Those have to be decided by the court.
Already that is the.
How
by
does,
way of-
just because you are in possession, how can the court even hold you in possession?
Possession and possession, they are not disputing in regard to possession. Maxim in regard to suit for partition.
But possession does not enter into a partition suit. You have to prove title.
No, I am not. This is a preliminary order, prima facie order. What is the contention for passing and
Nothing has been adverted to. None of the parties' arguments. They say that it has been acquired. Do you agree that 17 has been acquired?
Not at all.
What is your contention on that?
That was also they have
What is
also
your stand on that? What is your contention on that acquisition?
my contention. It was never acquired. Till date, originally my predecessor was the original owner.
They must have produced documents to show
Yes,
acquisition.
They have not nothing.
My transfer
Only-
deed depicts the
only-
property.
Their transfer deed regarding 4th decimal
Yes,
has been
That is not in dispute. That my predecessor conveyed the.
It's a demarcated 4th decimal, your predecessor. Then where is the question of partition? He is an owner, absolute owner of that 4th decimal.
Again, it will be hard approach as your lords.
That is what we are saying. Nothing has been considered here.
Yes.
On consent of the parties, we are taking up the appeal application together. Otherwise, no use. Whatever way we go, it will. On consent of the parties, the appeal and the application are taken up for hearing together by dispensing with other formalities, since the contesting parties are represented through counsel. Full stop. Next para. The plaintiff stroke respondent filed a partition suit in respect of 21 decimals of land of property. Full stop. Next para. The defense of the appellants was that out of the said 21 decimals, 17 decimals have been acquired by the state, whereas the balance 4th decimal was transferred by demarcation exclusively to the defendant stroke appellants by the predecessor in interest of the plaintiff stroke respondent. Full stop. Next para. Learned counsel for the appellants argues that by the impugned order, a blanket order of status quo was passed without adverting to any of the contentions of the parties or without any reason. Next para, learned counsel for the plaintiff respondent opposes such contention and argues that the learned trial judge took into consideration the arguments of the parties, and upon arriving at a conclusion that there was a prima facie case made out and that the position of the plaintiff was undisputed, granted the status quo. As such, it is contended by the respondent that the impugned order ought to be sustained. Next para. On a careful perusal of the impugned order, we find that although the narrative contains the arguments of the parties, the impugned order is absolutely cryptic insofar as the reasoning is concerned. The learned trial judge merely proceeded on the premise that the issue raised by the defendants is not liable to be determined at this early stage, and to determine the same, evidence is required, without taking into consideration that even on a prima facie footing, the learned trial judge was required to advert to the contentions and documents of the parties. The learned trial judge observed that prima facie it appears that the suit land is in possession of the plaintiff as well as the defendants, having right, title and interest over the cost scheduled property, and that a prima facie case and balance of convenience and inconvenience was made out. However, paying lip service to the parameters of grant of injunction would not suffice. The impugned order reflects absolute non-application of mind of the learned trial judge to the materials on record, the documents produced by the parties and the respective pleadings of the parties, vis-a-vis acquisition and transfer of demarcated specific portion of the property in favor of the defendant stroke appellants. As such, the impugned order cannot be sustained in the eye of law. However, keeping in view that the respondent was enjoying an ad interim order of status quo during pendency of the temporary injunction application in the trial court, we are of the opinion that the purpose of justice would be subserved if for the interregnum, similar protection is granted to the respondent, directing the matter to be reheard and redecided by the trial court. Next para. Accordingly, FMA 446 of 2025 is allowed on contest, thereby setting aside the impugned order and directing the learned trial judge, setting aside the impugned order bearing order number 12 dated January 28, 2025, passed by the learned civil judge bracket senior division second court at Kontai district Paschim or Purbo Medinipur in title suit number 164 of 2024 and remanding the temporary injunction application to the learned trial judge for a fresh hearing and re-adjudication of the said application on merits on the materials already on record. Full stop. Next para. The learned trial judge shall re-adjudicate the temporary injunction application finally upon hearing both parties on the evidence already on record, evidence and materials already on record. Full stop. There shall be both parties shall maintain status quo regarding the suit property till disposal of the temporary injunction application. Full stop. It is expected that the learned trial judge shall complete such exercise as directed above as expeditiously as possible, positively within 1 month from the date of communication of this order to the learned trial court. Full stop. Can 1 of 2025 is disposed of accordingly as well. Any interim order was passed? No. There will be no orders to costs. এটা জাজমেন্ট ফর্মে হবে কিন্তু ডিক্রি নয়।
সার্টিফাইড
আচ্ছা প্রথম লাইন হচ্ছে এফিডেভিট অফ সার্ভিস ফাইল টুডে বি কেপ্ট অন
আই এম গ্রেটফুল
চলুন